Ya, berzoom.
Alhamdulillah sudah bisa join
Alhamdulillah.
di sini. Iya.
Ya,
Okay.
saya diberikan saya punya PowerPoint. Boleh doktor nanti tolong paparkan?
Bisa, ada teknisi yang siap untuk ini.
Yang tolong
Operasional, iya. Iya.
Thank
Sudah
you.
siap Ibu, iya. Kami menunggu Bu Rohaida ini, Prof. Maman sudah. Oh ya, Prof. Maman, ini Bu Dekan Yusim sudah gabung. Sebenarnya sudah ada di.
Oh, Ibu Rohaida udah masuk.
Ya nantilah.
Assalamualaikum.
Makan.
Ya, Assalamualaikum Prof. Apa khabar?
Oh, baik.
Banyak yang.
Oh iya, ini salam kenal Ibu.
Ya, salam kenal. Rasa macam kita pernah jumpa Prof.
Oh iya, siap.
Ya.
Waktu dulu ya kita ke sana, ya.
Ya, ada ingat.
Ibu baru
Hari
ya?
ini ya, saya baru saja saya menggantikan tempat dekan yang hari itu ada masalah kesihatan sedikit. Jadi untuk hingga hujung tahun insya-Allah.
Ya. Ya, selamat bergabung ini, selamat berkenalan. Kemarin saya request Dr. Hasmi supaya dekan berkenan untuk hadir di Zoom meeting.
Assalamualaikum warahmatullahi wabarakatuh.
Salam.
Waalaikumsalam.
Prof.
Ya.
Nur.
Ya, waalaikumsalam.
Bu Aryuni.
Assalamualaikum
semuanya.
Waalaikumsalam.
Waalaikumsalam.
Ini pembicara dari kami, Bu Nur Fadila. Iya, Prof. Trilisiane. Ya, Prof. Trilisiane.
Prof. Trilisiane. Apa khabar Prof? Selamat datang.
Iya. Assalamualaikum Bu Rohaida, sudah join juga? Sepertinya.
Ya, waalaikumsalam Ibu Aryuni.
Alhamdulillah. Berjumpa lagi nih. Masih tetap awet muda nih. Awet muda. Iya. Silakan Ibu ini mengobrol dulu dengan mengobrol dulu sambil menunggu Bu Rip. Sepertinya belum join ya. Kita ya.
Okey.
Ya, Assalamualaikum Prof. Dr. Haida. Fadilah dari Mesir.
Fadilah, apa khabar? Dr. Fadilah.
Jauh kita jumpa. Oh, thank you. Membantu meneruskan agenda-agenda fakulti.
InsyaAllah moga dipermudahkan urusan. InsyaAllah.
InsyaAllah, terima kasih. Jauh kita jumpa kat sini pula.
Sedangkan kita 10 kilometer je kan?
Dekat saja.
Musim dan UKM. Dr. Fadilah, clear tak dengar suara saya?
Dengar clear, very clear.
Alhamdulillah. Saya hari ni terpaksa berzoom dari rumah. Dekat UKM kan takut dia, walaupun pakai Selcom, tapi sebab fakulti atas bukit, jadi kadang-kadang dia tak stabil.
Ya. Okey.
Dr. Fadilah pun dari rumah ke?
Saya pun dari rumah sebab di office biasalah ada banyak urusan yang lain dan juga ada renovation yang berlaku tu, takut bunyi bising.
Bising ya.
Ya sebenarnya aneh aja sih, maksudnya di luar negeri ya pasti juga nggak ada SNI-nya dong. Iya, harusnya biasa aja. Namanya masker kalau udah ada standarnya ya udah.
Di pukul berapa Bu Ida? Di Malaysia pukul berapa?
Sekarang 5 minit lepas 11.
11, pukul 11.
11 5 minit.
Oh, oke. Bu Nur, di tempat Bu Nur pukul berapa? Bu Nur, Bu Fadilah?
Oh ya, sama. Oh,
sama.
saya panggil saya Fadilah.
Oh, Bu Fadilah.
Sebab kalau Nur saya tak tahu saya dipanggil. Okey, Fadilah.
Pukulnya sama, 11:05.
Sama sebab kami dengan UKM dekat saja, tidak jauh.
Okay. Ya.
Memang satu zon.
Oh, tak ada selisih waktu ya?
Tidak ada.
Tidak.
Pukul 11.05 juga.
Dari Bangi ya, dekat Bangi ke.
Dekat Prof.
10
Very near.
kilometer je Prof Ade.
Iya, betul. Sehat Bu Raida? Lama
Alhamdulillah. Bapak Dekan sihat adanya.
Alhamdulillah. Iya.
Itulah kami nak ke sana tak boleh, yang di sana semari pun tak boleh. Tak apalah.
Ya.
InsyaAllah segalanya bertambah baik tahun hadapan, insyaAllah boleh face to face.
Amin ya, kita bisa saling berkunjung.
Amin.
Kondisinya ini kadang ya kita tidak tahu ada.
Situasinya di Yogyakarta tu terkawal ke Bapak?
Oh, yang mana ya? Yang
COVID-nya, COVID.
Oh.
Terkawal? So,
ini di Jakarta lebih ini apa ya? Situasinya lebih teruk, jelek ya, tidak baik ya. Kita di Purwokerto masih relatif aman ya, walaupun sama aja sebenarnya. Di berbagai tempat ada lah sekarang. Tapi Jakarta paling scaring, menakutkan lah. Kita juga takut ke Jakarta ini. Ya. Kemarin saya dari Jakarta juga cuma 2 hari terus pulang.
Okey. Kami di Malaysia agak terkawal ya Dr. Fadilah kan?
Alhamdulillah.
Terkawal sebulan lepas, tapi kemudian ni ada second wave di Sabah sebab ada pilihan raya. Jadi statistiknya daripada 1 digit sudah kembali ke 3 digit sekarang. Jadi agak merisaukan. Jadi yang di Sabah tu yang kempen pilihan raya, even yang dari universiti pun sekarang balik ke universiti, ke UKM. Jadi UKM tak bagi masuk office. So di kuarantin 14 hari.
Ya. Banyak ya. Nanti banyak ini kita bicara perkembangan pemerintahan dan hukum tentunya ya selama pandemi ini. Banyak polusi-polusi yang tadinya tidak direncanakan terjadi pada saat ini. Mungkin nanti pemilu kada dan sebagainya juga menarik untuk dibahas. Ini ada pilihan raya untuk di local government akan pemilu raya gitu. Apa ini di postpone apa jalan terus kita tidak tahu ini masih betul. Nanti ada mungkin yang bicara itu kayak di tata negara mungkin ya.
Iya. Banyak isu undang-undang ya yang terlibat. Ya, di sini pun pelajar diwajibkan menulis kertas research dalam topik bahasa Inggeris.
Dr. Hasmi, Assalamualaikum.
Waalaikumsalam.
Iya ini. Biasanya paling sering ke sini. Paling sering ke Indonesia, ke Purwokerto ini. Dr. Hasmi.
InsyaAllah tahun depan setelah vaksin.
Iya. Biasanya tiba-tiba ada, tiba-tiba hadir, jalan lagi, tiba lagi. Sekarang hanya di layar screen saja.
Di layar screen tapi kerja-kerja antarbangsaan masih berjalan.
Oh jalan ya, kita silaturahim jalan tetap ya.
Betul.
Ya, medianya ini yang bisa.
Selamat datang Bu Prof Rifda, ini sudah hadir Prof Maman.
Oh iya. Halo Prof Rifda.
Terima kasih. Mohon maaf ini sambil di lab.
Oh, ya. Ini bukan lab COVID kan?
Lab.
Bukan lab yang
Pak?
Bukan lab ini COVID bukan ya, lab bukan swab bukan ya?
Betul.
Ini COVID
masa lab swab? Oh, lab COVID ya.
Sehat Prof Rifda?
Alhamdulillah sehat selalu. Terima kasih Prof Ade.
Iya.
Assalamualaikum Bu Rifda.
Tuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Jadi kapal Malaysia udah bisa masuk ke Indonesia gitu.
Ya. Mungkin
sudah,
dia sudah lengkap, bisa dimulai nih. Ya, bisa dimulai. Ya. Silakan. Ya, ini Mbak Ulil yang akan menjadi moderator dan
Terima kasih. Ladies and gentlemen, attention please. We'll be starting this virtual event shortly. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Waalaikumsalam.
Salam, Om Swastiastu, Namo Buddhaya, Salam Kebajikan. The Honorable Head of Research and Public Service Institute, Jenderal Sudirman University, the Honorable Dean, Faculty of Law, Jenderal Sudirman University, the Honorable all invited speaker from UNSUD, UKM, and USIM, the respected guests and all the audiences, good morning. It's my pleasure to welcome everyone to the webinar series of Faculty of Law, Jenderal Sudirman University. Visiting lecture with the theme The Dynamic of Law, Indonesia and Malaysia Perspective. This webinar held by the International Research Collaboration Teams in Faculty of Law Jenderal Sudirman University as one of our research outcome. Faculty of Law Jenderal Sudirman University have strong commitment in implement the cooperation program with our partner university. In this regard is UKM and USIM concerning the research and academic program. Before we begin, we would like to greet all the audience who kindly get to us through Zoom and our official YouTube channel. We have participants from various universities all around Indonesia. From Sabang to Merauke, we have participants from Papua. We also have participants from Sulawesi, Jawa, and Sumatra. We also have international participants from UKM, USIM, also from Crown Hill University, Nigeria, and etc. We are truly grateful and delighted to have you all. I also introduce myself. My name is Ulil Afwa, lecturer in Faculty of Law, Jenderal Sudirman University. Here I am as... Now, before we begin, let me remind that the participant audio will be mute and can be active in the Q&A session after the presentation from all the speakers. The participant can ask by raise hand or can question on the Q&A session. All right, ladies and gentlemen, to start the session, let's take prayer to Allah Subhanahu wa Ta'ala, the God Almighty, for His blessing and guiding to us holding this event. For the Muslim, by praying Basmalah together, and other can praying accordingly. Bismillahirrahmanirrahim. Thank you. Now, firstly, we will have welcoming remarks from the Honorable Head of Research and Public Service Institute, Jenderal Sudirman University, Professor Rifda Novalin, SPMSC. The time is yours. Prof. Rifda Novalin, SPMSC.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Kami hormati Bapak Dekan Fakultas Hukum, Profesor Dr. Ade Maman Suherman. Yang kami hormati Ibu para narasumber, Dr. Nur Fadilah Mohed Ali dari Universitas Sains Islam Malaysia. Yang kami hormati Associate Profesor Dr. Rohaida Nordin dari Universitas Kebangsaan Malaysia. Yang kami hormati Profesor Tri Lisiani Prihatina dari Universitas Jenderal Sudirman. Dan yang kami hormati pula peserta semuanya, baik itu dari UNSUD, dari berbagai fakultas hukum, dan dari Malaysia. Puji syukur kita panjatkan kepada Allah Subhanahu wa Ta'ala. sehingga pada pagi hari ini kita bisa bersama-sama bertemu di sini walaupun pada masa pandemi COVID, tapi kita tetap bisa melaksanakan berkarya, berkontribusi untuk membangun negeri. Bapak Ibu yang kami hormati, kegiatan ini merupakan salah satu bagian dari kegiatan yang seharusnya international research kolaborasi dari UNSUD melaksanakan kegiatan ke Malaysia dan dari Malaysia melaksanakan kegiatan ke UNSUD. Namun demikian ada kendala sehingga dilaksanakan kegiatan secara virtual ini. Kegiatan visiting lecturer ini diberi tema yaitu The Dynamics of Law, Indonesian and Malaysian Perspectives. Saya sangat apresiasi sekali ini dari Fakultas Hukum, sudah kali kedua, kemarin sudah FGD, sekarang visiting lecturer. Ini saya kira bagus sekali untuk meningkatkan kerjasama antara UNSUD dengan universitas di Malaysia. Ini kami terima kasih kepada USIM dan Universiti Kebangsaan Malaysia yang telah berpartisipasi untuk kerjasama dalam research maupun dalam bidang pengajaran. Mudah-mudahan acara seperti ini bisa berlanjut terus. Ini terima kasih kepada para narasumber dari luar dan dari dalam UNSUD sendiri. Mudah-mudahan nanti bisa terus-menerus walaupun nanti sudah tidak masa pandemi, international research kolaborasi bisa dilaksanakan seperti ini. Mungkin itu yang bisa saya sampaikan. Kami dari mewakili LPPM Universitas Jenderal Sudirman mengucapkan apresiasi sebesar-besarnya kepada Fakultas Hukum yang sudah menyelenggarakan acara ini. Mohon maaf apabila ada salah kata. Selamat mengikuti kegiatan ini. Saya akhiri. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Thank you very much, Prof. Rida, as the head of LPPM Jenderal Sudirman University. Now, the next is opening remarks from Dean Faculty of Law, Jenderal Sudirman University, Profesor Dr. Ade Maman Suherman, SH, MSc. The time is yours.
Baik, terima kasih. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Selamat pagi dan salam sejahtera buat kita semuanya. Good morning, ladies and gentlemen. First of all, I would like to thanks to Allah Subhanahu Wa Taala, the Almighty God, and in this morning we can gather here in a virtual meeting and organized by Faculty of Law. And also, I would like to address my special thanks to the head of Research Center, Jenderal Sudirman University, Prof. Rida Novalin, who already delivered speech to us. And also, I would like to thanks that all the funding already given to us to have kind of research collaboration between two universities, between USIM and UNSUD, and also University Kebangsaan Malaysia. And I hope in the next time, in the future time, we can gain more funding from Research Center Jenderal Sudirman University. And also in this very leisure time that privileged to me, that is very glad to meet here in this virtual meeting. I would like to appreciate and I would like to thanks also to all the speakers from University Kebangsaan Malaysia, Ibu Rohaida, who already visited us many times, and also to the Dean of Faculty of Law, University Sains Islam Malaysia, Dr. Fadila. Welcome to this meeting. I think it is the first meeting, and also we can introduce each other by this meeting. And also, last but not least, I would like to thanks also to Dr. Hasmi, who organized everything before from Faculty of Law, University of Sains Islam Malaysia. Ladies and gentlemen, also I would like to thanks to the speaker from Faculty of Law, Prof. Trilisiani, PhD, will deliver a presentation about maybe about gender or about something else. Will be together with me. Also, I will be one of the presenter in the next session. Ladies and gentlemen, I would like to thanks also to all the participants. And I watch in this monitor that there are 144 participants who already joined in this virtual meeting. And I do hope from this visiting lectures, we can produce something fruitful conclusion or maybe decision or kind of a very productive and constructive discussion about two legal system and the dynamic of legal system or the dynamic of Indonesian and Malaysian legal system. Hopefully we can also discuss about today condition, because all over the world and including Indonesia and Malaysia experiencing some kind of difficult situation to transfer knowledge from the lecturer to our student, and also kind of difficulties also from the government to serve the people in its countries, like in Malaysia or Indonesia. So in pandemic time, so everything and everywhere looks like very hard to be survived. And I hope also through this meeting, even we cannot see each other in Malaysia or Indonesia. Actually, I would like to report to Prof. Ripda that at the very beginning stage, we do expect to visit USIM and UKM, or the other way around from Malaysia to Indonesia. But unfortunately, because the situation is still like this, I mean, we don't know it will end until when, I don't know, and we don't know. But we do hope that this kind of hard condition we can will end in the near time. Ladies and gentlemen, also all students, all participants, I would like to welcome to this visiting lecture program between Indonesia and Malaysia, and organized by 3 universities, Jenderal Sudirman University, USIM, and UKM. And I would like to fulfill the request from the moderator to open this visiting lecture with saying Bismillahirrahmanirrahim. The dynamic of legal system or Indonesian law and Malaysia officially open. Okay, terima kasih. Thank you very much. Thank you for your attention and for your attendance in this visiting lecture programs. Thank you. Mohon maaf bila ada kata-kata yang kurang berkenan. Billahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Thank you very much, Prof. Ade Muhammad Suherman as the Dean of Faculty of Law, Jenderal Sudirman University. Ladies and gentlemen, now the webinar is officially open, and it's my honor to invite all the speakers for this online visiting lecture program. Joining today is 4 amazing visionary speakers. I will firstly introduce them all and their short biography. The first one, we have Dr. Nur Fadilah Muhammad Ali. She is the Dean of Faculty of Law, University Sains Islam Malaysia. Graduated from International Islamic University Malaysia and PhD from Center of Petroleum Mineral Law and Policy, University of Dundee, where she received the Dean Medal for Research from the Graduate School of Natural Resource Law for her PhD thesis in International Investment Law. She is an alumna of Arbitration Academy in Paris and also holds Certificate of Mediation from the Accord Group, Australia. Good morning, Dr. Nur Fadilah. You are pleased to say hi and greet all the audiences.
Hi, Assalamualaikum.
Waalaikumsalam. Okay. How are you?
Yeah,
Dr.
I'm fine. Everyone, I hope everyone is fine too and having a good day today.
Okay, thank you. The next speaker is Professor Dr. Ade Maman Suherman, SHMSC. He's the Dean of Faculty of Law, Jenderal Sudirman University. He's complete Master in University of Groningen, Netherlands, and Doctor of Philosophy in University of Indonesia. Formerly, he's also commissioned for the Directorate General of Intellectual Property, Ministry of Law and Human Rights, Republik Indonesia. Good morning, Prof. Ade Maman.
Yes, good morning. Even we have very close room each other.
Yeah.
Good morning.
Okay, thank you, Professor Dr. Ade Maman. Now the next speaker is Associate Professor Rohaida Nurdin, PhD. She is head of postgraduate program University Kebangsaan Malaysia. She completed master program in UKM and doctoral in Lancaster University, UK. Good morning, Ibu Rohaida.
Good morning, Ulil. Good morning, everyone. Selamat pagi, and it's a great honor for me to be part of this program. Thank you.
Thank you, Ibu. Okay, the next speaker is Professor Tri Lisyani Prihatina, SHMA, PhD. She completed her master and doctoral program in Murdoch University, Australia. She is well-known professor in private law at Faculty of Law Jenderal Sudirman University, also chairman of private and business law in doctoral program Faculty of Law Jenderal Sudirman. Good morning, Prof. Tri Lisyani.
Good morning, Mbak Ulil. Assalamualaikum warahmatullahi wabarakatuh. All participants, Bu Ida, Prof. Maman, and Bu Nur, ya?
Bu Fadilah.
Bu Fadilah, yeah. Yeah, I call her always Bu Nur, ya, Bu Fadilah.
Yeah.
Good morning, all. I hope we can share knowledge about the interesting topics.
Yeah.
Okay. Thank you, Mbak Ulil.
Okay, thank you, Prof. Tri. All right, ladies and gentlemen, today they will sharing their perspective on the various issues related to the dynamic of law. As we all know that the dynamic of law has influenced by many factors. Today we will hear insight and discussion on the dynamic of law from various aspects. Among others are aspects of international investment law, global health governance, Malaysia perspective, and how they contribute to the international world. Okay, without further ado, please welcome the will be presenting about trend and emerging legal issues in international investment law. Ladies and gentlemen, please welcome. This is Dr. Nur Fadilah Muhammad Ali. Time is yours.
Okay, thank you very much to everyone, and I would like to give my special thanks to the organizer from Jenderal Sudirman University, Prof. Ade Maman, and Prof. Rida as well just now, and from a fellow colleague from UKM, Associate Professor Dr. Rohaida, my colleague from USIM as well, Associate Professor Dr. Hazmi, who is always helping in the engagement of international affairs, and other fellow speakers, as well as all of the audience that we have today. So my paper, which I'll be presenting, is on trends and emerging legal issues in international investment law. Can I have the slides on, Mbak Uli? All right, for us to see. Okay. Okay. So what I'll be basically talking about is the trends and emerging legal issues in an area of law of which is relatively new in the development of international law. So international investment law is basically a field in international law that governs the relationship between states and foreign investors. So from this body of law, it creates obligations to host states like Indonesia or Malaysia or any other states which are parties to it in order to provide protection for foreign investors that come into the states. And from these obligations, if there is any breach of these obligations, it allows a very powerful clause inside it that is called as the ISDS clause, the International Dispute Settlement Clause, which allows foreign investors a direct access to bring the states, the host states, to arbitration. So now, to give you an idea of how huge this area of law is, we will later on see that in the from 1959, on which the first bilateral investment treaty was entered into until today, there are more or less 3,000 investment treaties that are in force. So if you see, for example, Malaysia has 100 plus investment treaties. Indonesia also, I believe, have a similar number, in which we enter into with other states to provide protections for foreign investors. And in 2018 alone, this is a report which I've seen, 2019 report of World Investment Report under ICSID, another 40 investment treaties were entered into. But well, there are many investment treaties, but right now there is a lesser number of investment treaties which have been entered into, basically just because most of the countries have already signed treaties with other countries of the same number, okay? So, well, the number is huge. And along with it, as I've mentioned just now, there is this dispute settlement mechanism in which investors can bring cases against states. And in 2019, there are 71 new ISDS cases brought. And to give you an overview as well, around the world, we see there are many arbitration centers which are set up. This is to allow investors to come and use the facilities within the arbitration centers, to allow to use the rules and to let them facilitate. They have their own pool of arbitrators to assist investors and states to settle the disputes. Okay, so now let us look at the next slide. Next slide, we will see on the standards of protection. There are various aspects in investment treaties which are called as the standards of protection. In the slides before that, entitled Standards of Protection, one of the first protection is protection against expropriation. Second is protection against most favored nation. These are the principles which are contained: most favored nation provisions, national treatment provisions, fair and equitable treatment provision, full protection, security, and free transfer of investment and returns. Okay, so okay, we're still finding the slides. I'm sorry. Yes, this one. Yes, this one. The next one. Okay, so if we go on to the next slide, we will see that these standards of protections are protections which appear in almost all of these 3,000 treaties. Okay, so even though these treaties are entered into separately by states, however, we see the similarity, the striking similarity of the provisions. But if we notice that most of the treaties contain these protection minimalist in nature, they are identical, but they are so simple in that it opens a lot of interpretation. By the arbitrators, especially. So because of the interpretation that is open to various ways or approaches, then we have seen also in investment international law today that there are many decisions which are inconsistent with each other. There are two approaches in this. One is some views are saying that well, we need stability in international investment interpretation, because by stability it creates flexibility, it creates a legitimacy or coherence in the decisions made by arbitrators. But on another point, the other view would say that we need flexibility, and that each of the interpretation should be given the power to the arbitrator to decide, and therefore it will be more context dependent. Okay, so from all these standards of protection, we'll see the first one, expropriation, is one of the most concentrated issue. Okay, in expropriation, especially in 1970s, where host states were alleged. There were many issues where host states have expropriated. Expropriation means taking away foreign investors' property, foreign investments' property, and without giving them a compensation. Well, this is under international law. It actually recognizes states to have the right to nationalize or expropriate, but it must be subject to certain conditions under customary international law and investment treaties. So every expropriation must be done by way, if the host states can show that there is public interest, there is non-discrimination, and that fair compensation is given. So basically, when you see, in a simple word, if the state now has already put a guarantee that if foreign investors come to the state will not take away the property of the foreign investors, and therefore the foreign investors will feel at ease. They will feel confident. They will feel that they are guaranteed that they can do their business without any interruption, especially by political interruption of the host states. So in the 1970s, what happened was there were a lot of expropriations that had occurred, and those expropriations were in the form of direct expropriations, where there was a transfer of title, taking in total the ownership of the foreign investors. So normally what we have seen in the 1970s were those in the oil industry. There are cases like Topco against Libya American Oil Company, Liamco against Libya, and etc. But time went by, and we saw the direction of expropriation is not much concentrating on direct expropriation, but now it is more towards indirect expropriation. That is, there is a degree of which the host states introduce legal measures, okay, for various reasons. For example, for reasons of environment, for example, or reasons of national security, or reasons of economy, that would cause foreign investors being deprived from their ownership of land, or ownership of their business. So it destroys the economic value and deprives the ability of the foreign investors to manage, to use, or to control the property in a meaningful way. So if they feel that because of the regulatory measure that the government introduced, it would cause them not to have the profit that they have expected earlier, then there would be a possibility that the states would have breached the expropriation principle under standards of protection under international investment law. And another issue that comes together with this was the amount of compensation. There is also no clear direction of how the compensation should be. So of course, foreign investors, when cases were brought to arbitration, they would want full compensation, as in the Hull formula. This is under customary international law. And they want full compensation that would also include the loss of future profit, etc. So there were arbitrations which provided what the foreign investors wanted. But there are also other views, another approach which says that the direction should be of fair market value, and that is under the idea of the approach of just compensation. Okay, let us look at the next slide, please. Now I'm concentrating on national treatment. Next, this national treatment comes together with another treatment that is called as most favored nation treatment. Basically, it upholds the principle of non-discrimination. When host states enter into this treaty, what it means that the host state has guaranteed to foreign investors that they will be treated similarly as how the host state treats their own local investors. That means whatever I give to my local investors, I will also give it to you. So, well, this is a huge issue today, because today we have seen that after states become state, the rising of nation states, where states have their steering their own direction in self-determination economy, the states would understandably be protecting the local investors or the domestic investors here. And so be providing, for example, if we see here and then subsidies and etc. So foreign investors, when they come in, they see that they are being discriminated, and therefore this could give rise to a breach of national treatment. This is in comparison in the olden time in Latin America, long time ago, not long time ago, about 1902, you see there. In the past, when foreign investors came and do business in the host states, here is examples of Latin American countries. The host states said that you should be treated the same as the locals, but they did not want to, because the status of the local investors at that time was lower than the international minimum standard. So in the past, the competing international standard, the foreign investors wanted the standard to be as minimum international standard under customary international law. Then this came the Calvo Doctrine, in which in the past, the Latin American countries, they insisted that foreign investors must be given treatment as how we give the local investors. So now it's the opposite way, and now because local investors are receiving a lot of privileges by being locals, and now the host states are put in the situation that they have to regulate within their means not to discriminate foreign investors. So this is one of a standard of treatment that is relative in nature. It is not absolute. It depends on whatever treatment that is given by the host state. Okay, so next please. Right, and these are one of the issues that we find in international law, which is pressing, which is always being talked about. It is the inconsistency of the awards, and the inconsistency of the awards occur because of the nature of arbitrations. As we know, the entry into of bilateral investment treaties were not designed, were not made as a system at the first place. It's not designed. States entered into separately, but the composition in the investment treaties were more or less like similar. And then when there were disputes that occur between states and investors, the investors brought cases to different arbitrations. Most of them are ad hoc arbitrations. They can choose any institution arbitration that they want. And therefore we see that there are many forums. And these forums, each arbitral forum will only be doing their job again within the mandate that is given to them. So the mandate is basically to resolve the dispute in front of them. So they basically actually, under the whole, if we call it a structure, sometimes people would say that it is not right to call it as a structure because there's no structure, or it is not right to call it as a regime, the whole international investment law, because it is not a regime. But there are other scholars who are also claiming that because of its mass implementation in nature, 3,000 treaties with similar investment protection, and therefore what else to be called? It is a regime or emerging regime. So basically, because of it being different or not in one basic system with other investment treaties, so arbitrators were basically asking these questions: do we have to follow the decisions of other arbitrators? So, well, apparently the arbitrators are not bound by the principle of judicial precedent because of the nature of this, as compared to domestic system in common law, for example. Especially, we have judicial precedents in order to create a consistent or coherent legal system. All right. So these were the issues, and this is continuously is now an issue, whether consistency is a requirement or not. So what I put here is preferred future. Preferred future is something that is basically what I see is what do we actually want. So this perhaps would require further research to see what is the preferred future that we want for international investment law, and this could be different based on whose perspective it is. So if you ask investors, the preferred future would be that we want flexibility. We do not want any because the consistency in jurisprudence is not their concern. But for host states, for example, would probably want consistency because it will reduce a lot of mistakes in regulatory measure that would end the host states in investment arbitration that would cost a lot of money, that would cost the money, the taxpayers' money of the state. Okay, so in level playing field is one of the intended purpose of investment treaties, that is to ensure that foreign investors are given the same chance as given to local investors. But it has always been a challenge, even though the treaties were entered into because of that. From day one until today, it has been a great challenge, especially in the implementation. So by having level playing field, this is what host states say, that when host states entered into bilateral investment treaties, host states then have a more attractive investment atmosphere, and by having level playing field, investors would be attracted to come to the state. Okay. So the question is next is protectionism. Protectionism is an issue because when we say when investment treaties are entered into, many multilateral investment companies come to the states. We see here, if we go outside, we will see KFC, for example, McDonald's, Shell, etc. There are so many big multilateral investment companies coming in our state, and these when they come in, understandably, the states would raise a little bit of whatever subsidy that they can to encourage the domestic investors to come and catch up with the world. So it is a very difficult relationship. The more investors come in, the more states becoming more strict in legislations, and the more protectionist the state is, and the more claims would come to investment tribunals. So, and with the rise of protectionism today, and we see the dynamics now, it is also different. Long time ago, we would understand that only developing countries or least developed countries would be very protectionist, but you see now even countries in the West are also becoming protectionist. We can see also the administration of Trump in the United States of America. We know that there is a rise of protectionism because of the shift of power. In long time before this, you would see that capital exporting countries were predominantly from the West, but now capital exporting countries are also coming from the East or coming from the South. So a country like Malaysia, we are capital importing countries, and at the same time we are also capital exporting countries in different circumstances. So there is an issue, especially when there are state-owned enterprises. Sometimes our oil companies in states are owned by states, and they receive some privileges, and there were also issues of harmful subsidy practices or market distorting behavior of state enterprises, which is an expansion of regulatory space for host states in the view of the investors, but from the view of the host states, many of the host states are of the view that these are the they need adequate regulatory space for governance. Okay, let's move on to the next one. Another issue that is around international investment law is the practices regarding environment. Now, we see now the trend is the investment treaties are now slowly putting in investment concerns or specific references to the environment in investment treaties. So because of the awareness, and now the governments are also moving towards designing better policies to reconcile openness. So when we open too much to foreign investors, for example, how do states reconcile this? How do states introduce legitimate regulatory measures to protect the environment? So there are also moves towards asking for open hearing, more transparency to see how treaties are being implemented, and in investment disputes, how the governments are doing in defending the environment by way of in their arguments, and also where appropriate to allow third-party participation in investment disputes or in investment arbitrations. So this is a challenge not only at the outset of the laws that we have, but also in practice and the behaviors of states. For example, in developing countries or least developed countries, we always hear the issues of corruption that is also it is, although even though it is outside the scope of international investment law, but somehow it is a noted issue that is people using or abusing the current setting under international investment law, which bring to a massive destruction of the earth. Okay, if we could name it that way. Well, then we would also be, the preferred future in this is green growth, and this is very much in line or aligned with sustainability agenda under the United Nations. Okay, now let us move on to the next one, that is how to reconcile international investment law with other obligations. So in this perspective, there are also other obligations that international investment tribunals may have come across when the host states argue on why certain regulatory measures are introduced. So host states would say that this is a concern under environment law, for example, international environment obligations, or under human rights principles, or under labor standards, or health, or etc. So again, it comes to the question where in the arbitrations or the arbitrators, do they have the obligation to talk about other obligations? Is it within their mandates as arbitrator? And there is this observation that arbitration is to resolve disputes. But if we go to, for example, the PCIJ or under international law, because this is a mix between private law and private international law and public international law. So when it is private, it is between the parties, but now it is also concerning the public, because the parties which are being sued or being brought to arbitration are states, and therefore states are talking on the capacity of it being a sovereign and having citizens. And so whether if you go to PCIJ, for example, it is legislator oriented as compared to arbitrations. So we see more of the activities of creating jurisprudence, not only to resolve dispute, but creating jurisprudence that law should be like this and like this and like this. But for arbitrations under investment tribunals, the scope is basically only to resolve disputes in front of them. Or even though we see that there are some arbitral tribunals that are slowly taking the approaches like the PCIJ, for example, to talk about something more, something more that is within the concept of law, of which people could take afterwards, all right, as a guidance. So what is the preferred future in this? To me, in my perspective, is to create economic good in an environmentally and socially friendly manner. So So the development must go in line. The international investment tribal agreements must be updated in its preamble, in its purpose, that it is no longer to be because to protect foreign investors or to enhance economic development of states, but it must also include elements of sustainability, to include social equality, economic equality of the people. So by that, by having including the responsibilities of foreign investors, then there would also be probably a chance or a situation where in the future where it also allows access to arbitration by states as compared to what we have right now, that the access for arbitration or dispute resolution is only opened for foreign investors. Okay, so the next slide, please. Okay, so the drivers of change, this is, I think I have mentioned a little bit when we were discussing about the development of law. Well, because of the doctrine of liberalization, we saw how the world has become globalized, especially after World War II, where there were massive destruction, especially in the West, and we also saw the European Union, establishment of European Union, in which states in Europe have taken lesson that if we do not do business together or cooperate in international business together, then we would fall into another war. So well, now we are actually experiencing a relative peace, we call it, not total peace, but relatively more peaceful than the situations before that. And because of the decolonization of states, new states, nation states rise, and because of the need of each of these states for economic development, that was why many of these states entered into these investment treaties and to encourage in capital exporting companies to come in. So there were also talks about why do developing countries sign into BITs when developing countries already know the consequences, because each breach of the provisions will be brought to investment arbitration, and it would cost a lot of money to the state. And that is what why some people are criticizing on why we are signing too many BITs. But still, there is this dilemma because host states need development, and basically what we are experiencing today is also a sign or the benefit of the development that have occurred because of these enabling laws. And then also because of the New York Convention, this New York Convention recognizes awards. So if the investor brought a case in an investment arbitration, and that investment arbitration gives an award, the award is the decision. This decision or award can be enforced in states. So many states have already signed New York Convention. So basically, the award can be enforced in many states. All right. So another one is the development of ICSID, UNCITRAL as the model law, in which everyone is familiar of, and then international arbitration centers around the world. What facilitates even further is the technology in the era of 4.0 right now, and all the mega trends where people are moving from one place to another. And this is a huge transition from the past, where in the past, if there was any dispute between the investor of a country with the host state of another country, then the solution at that time was the host state will bring their gunboats and wait at the shore of the country and to attack. So that was what they call as the gunboat diplomacy. So it was a huge shift from gunboat diplomacy to the international dispute settlement by way of arbitration, from war to international economic cooperation. All right, so I've put there one coronavirus there. I hope it signifies coronavirus. Well, now this is a huge as well, something that we are facing, and there we also see how the states respond to this. Well, states have to be really careful because any regulatory measure will be challenged if it is depriving or jeopardizing the foreign investors. And that is why during the, like in Malaysia, we had a certain period of lockdown, or not lockdown, it's the tempo PKP we call it, where we were not allowed to go out, and that actually have a lot of impact to business. And we understand that states cannot prolong it too long because of the pressure of economy. Same goes to other countries like Indonesia or other countries. We understand the dilemma of the host states which they have to make in order to introduce measures, because each of the decision of the host states would trigger whatever obligations that are in the context of international investment law, in the context of foreign investment, the international investment law. All right, so we already see in coronavirus, when the outbreak of coronavirus a few months ago, where some states have already expropriated the private hospitals of their state, because by expropriating, so the government will take control of the facility and will be able to cater the needs of the country. Some states also have introduced banning of exports of medical equipment, etc. So there would be, right now, I would expect there would be there was short-term measures. There would be long-term measures which will occur. We will see how each states are responding to this. Okay, next is. All right. So watching the trends in interpretation. If you are interested in this, you can look at the the arbitration awards or cases. Okay, which are, many of them are online. You will see the direction. Right now, they're talking more about collective rights than individual rights. Sustainability are also creeping in. Discussions about that, okay? Cultural relativism, about national security, like for COVID-19, if there is any cases which are brought, would the national security be a question there? Most probably, I would see that host states are bringing this. And then precautionary principle, greening of domestic international law, and other principles like reasonableness, proportionality, and etc. So in the next box there, I'm introducing that even though in international investment law, it has no specific doctrine of justice, for example, as compared to courts of justice, but we should incorporate, or should have a higher level of law to guide the workings of international arbitrations, that is rule of law. And the rule of law would encompass the preferred direction to be economic equality, social justice, and environmental preservation. So the balancing tools that we have to bring towards that is, for example, the doctrines, the principles of reasonableness, principles of proportionality for legal interpretations. And this is for us to avoid the worst case scenarios of economic disparity, social injustice, and environmental degradation. Because if we run it automatedly, then we will see all of our rivers being polluted, and the hills being the woods are chopped, and etc. Okay, and my last slide is, these are the next slide, please, which is the last one. I've listed here what among the things which are happening and will be happening, in terms of international investment law is, number one, renegotiation of treaties, termination of outdated treaties, because many treaties are now becoming to the end of its duration, and then reforming the international dispute settlement mechanism to update the purpose of the regime. Talks have been talking about, towards that direction. The recognition of the need for policy space, and there are also countries which are remaining outside IIA. There are countries which have not entered into at all the investment agreement because of lack of trust of the system. The rise of protectionism, And there are also countries which are trying to enhance their national investor state mechanism for dispute resolution. That means the signal is not to allow any dispute to go to international arbitration, and then access to arbitration for states. So to me, as to conclude, this is just as simple as, for example, football, what do you call that? Football field where you play. You have certain rules, but if states are not happy with the rules, or the rules being used not in accordance to what is expected, then there is a chance that states would retract or withdraw from the whole system altogether. So what is the worst case scenario of this, which we do not want, is the failure of international cooperation in economy and the rise of protectionism, and what we really do not want is war which arises out of that. So thank you very much. That is all for my presentation.
Thank you very
As
much,
a
Dr.
spaghetti,
Fadila.
as a spaghetti bowl.
This very interesting presentation, and the issues is very interesting. We see many questions also in the chat room, but we will discuss the question in the Q&A session. If I can highlight, there is many important points from the first presentation. The first about the expropriation principle, and also the non-discrimination for the national treatment, and about how the economic equality and disparities also can uphold by the international investment law and the emerge of those kind of thing in the international world. This very interesting presentation from Dr. Fadila Muhammad Ali. Thank you very much. And then the next we will go to the second speaker. We have Professor Dr. Ade Maman Suherman will be presenting about global health governance and global pandemic, multi-track policy and state responsibility. Prof. Ade Maman Suherman, please, the time is yours.
Okay. Okay, still good morning for everybody. But maybe in Malaysia it's already good afternoon. Selamat siang, atau mungkin juga menjelang siang. Please, could you help me to share the slides? Okay. Okay. This is my second turn to speak here. I am very delighted to be here because we gather here with some very from guest lecture from Malaysia, Dr. Haida and also Dr. Fadila Muhammad Ali, and also with our colleagues from Jenderal Sudirman University, Prof. Tri Lisyani, PhD. Okay, this is my first slide. It's all about my publication, my books that already published in the market, and just skip it and next to the presentation. Here I would like, please back to my first slide, because I would like to highlight the title. Okay, back to my first slide. Yes. I would like to present here about global health governance and pandemic. It's a mixed presentation because I designed this presentation a few weeks ago, and I tried to present it again because it's quite interesting topic until today, maybe until tomorrow. It's about global health governance, and also we talk about multi-track policy and about state responsibility. So here we are here together using the virtual meeting because of this topic, because of pandemic, because of global pandemic is still going on until now. Okay, next. Yes, here we are watching two pictures. It's quite interesting pictures. Yes, the left side pictures is just two guys that's shaking hands. Other one of them, they are raised the director of WHO and also the president of China. Yes, everybody knows them, I think. It's a big question about in this picture. Yes, what are they talking about, because the big issues about pandemics already linked to this two persons, about from director of WHO and also from Xi Jinping. And also the right side, the picture here, that's it's about something dangerous here, because it's a deadly pandemic that's rising from China, yes, from Wuhan city. So until now, it's the impact of the global pandemic still going on in all the countries. Yes. Next, okay. So we are talking about globalization, and also here about challenges, how to overcome the global pandemics in COVID-19, because it's already always related to globalization. Yes, everything, trade, investment, and also pandemic and deadly disease like COVID-19. That is always connected with globalization. So yes, it's kind of challenge for us. There are two approaches how to overcome, how to have kind of a policy to anticipate the global pandemic here. So there are two approaches here. First is a horizontal and vertical health and vertical approach. So it's about a horizontal approaches from the public health problems. That's it's need kind of increased cross-border border microbial traffic, yes, caused by increased speed and volume of international trade and travel. So that's a very strongly related between the increase of cross-border microbial traffic caused by the increased speed and volume of international trade and travel, and also maybe investment as well. So also the population, the mobility of people from place to place, from one country to another country, and also product as well. The global product, global goods, services from one country to another country. So it's increased threats, yes, and also from the cross-border transmission of pathogenic microbes. And also the challenge here in this situation about pandemic in COVID-19, the challenge among many states. So this many states should coordinate each other, how to make strong coordination to make the same policy, how to formulate the common interest between the states, how to face this COVID-19. Next. Okay, this just kind of about our view about the global outlook. There are some weakness here. Yes, the weaknesses in domestic and public health system, and also the weakness of the surveillance and capabilities, because it's quite weak system, and because also in, for example, in Indonesia, this condition is really unexpected. Yes, because also all the countries, I think, they don't think that it will happen like this. So many weaknesses happen in many sections, many units in government's department and everything. So it's kind of the weakness that we have to anticipate until tomorrow, or maybe next year or next month. And the vertical challenge here, we talk about from national to the local level. So this it's still inside the territories of the country. Yeah, it is a vertical one. So the vertical approach is kind of domestic policy, how to implement the rule and regulation, how to anticipate, or how to kind of make good health for their citizen, good service, also kind of medical facilities, also hospital and everything. And also it's totally different between horizontal approach. The horizontal approach is need. We need more coordination with other states. Ladies and gentlemen, also we would like to see here, we talk about the vertical challenge should reform our public health practices and policies in our country. Also the globalization effect, sini globalisasi ya, and how to control and how to prevent the infectious disease. Ya. Also here menunjukkan bahwa states cannot deal with the horizontal or vertical challenge without cooperation. So here the key points here, the keywords here is cooperation. Yes, both cooperation among states and also cooperation inside the country itself. For example, in Indonesia, the government, the central government in Jakarta should cooperate, well cooperated with all the provinces, all the government in local government, and we know that Indonesia is totally different with Malaysia. Indonesia is huge countries and it has 34, I think, 34 provinces and maybe more than 300 districts, 350 districts in Indonesia. So I think it's quite understandable that the government has huge difficulties to prevent, to manage this pandemic in Indonesia, and also a huge population, a huge number of population in Indonesia. Next. Okay, now, okay, Indonesia as developing countries also needs kind of assistance or aid from developed countries or industrial countries, and also here about how to facilitate about cooperation in international cooperation, and also we need kind of international rule and regulation in global pandemic today. And also the issues in our country, there are two debates about, there are two main streams of idea. First of all, the people talk about we need to economic recovery. So we don't need to have kind of lockdown in very strict lockdown for a certain area. Yeah, but another idea that the highest priority in our life is how to save our life, about safety. Yes, so it's still running, still interesting to discuss about two mainstream in our country about which one that we should prefer. This about economic affairs or also about the healthy or about the safety for our human life. Okay, next. Now, so it's talking about international law related to infectious disease from the governance framework. So we need international law constitutes the body of binding rules. So it's kind of definition from Brownlee that international law constitutes a body of binding rules, yeah, that's govern relation between sovereign states. So it is also, I think, not on the state here, non-state as well. We need a relation with non-state or non-state entities. There are many, I think, many subjects of international law other than states, such as international organization or non-government organization, etc. So here, international law, yes, have a big role in the context of vertical, also in horizontal approaches in terms of how to prevent public health, also how to handle, how to manage the infectious disease. Next. Yeah, so we come to this slide, we come to this explanation about governance, how to respond to the global challenge here. About the regulation concerning pandemic or infectious disease. So nationally or internationally or regionally, we need kind of cooperation or strong cooperation, and also kind of good teamwork each other, how to anticipate the global challenge in facing the global infectious disease. in this term is COVID-19. So I think the key point here again, we need the international governance. That's how to formulate the norm. Yes, first of all, how to formulate the norm, and then also the institution, how to facilitate the international or interstate cooperation, both regionally or globally. Next. Yeah. So many policies, I think we need both internationally or nationally. So inside our country itself, or also in regional or in global cooperation. So we need global governance. It's quite interesting term. I think it's about specific terms as in international relation, also in international law perspective. The keywords of global governance, because we do accept this concept, because in global world we need global governance as well. So there are many institutions that really involved in global governance, such as non-state actors here, for example, multinational corporation or MNCs, and also international non-governmental organization, and of course United Nations, and also all the specialist agencies in the United Nations. Okay, ladies and gentlemen, so all the elements here, or the entities other than states, of course, we need help from the multinational cooperation, such as non-state actors, and also from international non-governmental organizations. The global community now is still speaking or discussing about the vaccine for COVID-19. So we cannot imagine what if producing the vaccine of COVID-19 without involving the multinational corporation. I think in all developing countries or in developed countries, we need these entities or MNC, how to handle or how to manage, how to serve the people by giving the vaccine or to save our life together. Ladies and gentlemen, for the next points, also multinational cooperation and non-governmental organizations. Don't move. Okay. We can also kind of shoulder governance, yeah, because MNCs and NGOs have a very strong roles in local or in national or in global governance. So we can say, in other words, that it's shoulder governance, yeah, because they participate and give more assistance for government to have a kind of big success to overall or in our endeavor. Next. Yeah. So we start to talk about regime. There are regime, international horizontal regime, or IDCs. It's a very past time, from 1855 until 1955. So it talk about all about history, yes, about the international and horizontal regime. We talk about the cooperation among states here. Yes, it's just historical perspective. I think just next to the next slides, please. Yeah. But basically, I think I can conclude that there are three regimes here. First, a classical regime. Yes. Classical regime start with the sanitary international sanitary convention adopted in the end of 1980s. Yes, about in the age of 19 until we mention it, we name it with International Health Regulation, IHO, and then again it promulgated by World Health Organization. So we know it all, so it's very familiar with us about WHO. So it's established in 1951. So it's still a classical regime that I already mentioned before. There are two very important people, person in the first slide at the very beginning presentation. They are director of this organization, World Health Organization, and President of Republic of China. Okay, it's all about international health regulation. Start from this organization, the WHO, that established in 1951. Okay, next. Yeah, we talk about, and then we move to another regime that's about organizational regime. This organizational regime represents a kind of international health organization and established by state, yes, of course, under treaties, yes, under international law as well. And this organization has kind of obligation to prevent or to handle a kind of infectious disease. And also about international public health in all the countries, in all member states. So here we still talk about specific duties on states in terms of infectious disease control. So here in Indonesian term, that's negara memberikan atau to formulate international health regulation by horizontal cooperation approach. Okay, next again, we move to the last regime. It's quite interesting. I think this regime is very strongly related with trade, also maybe investment. How the investment would be look like, and how the trade, international trade would be look like in pandemic time. So we have to refer to our international norm. Here we have to make kind of legal review, how the legal basis in international trade law in terms of pandemic time. So according to third regime here, yes, in third regime here, based on, okay, I cannot move this slide because I cannot read in the edge of this slide because this I have to minimize the picture maybe here. Okay. Yeah, sorry. Okay, done. Next to the previous slides. Yeah. Okay. Trade regime here. Okay. Yeah. We had to analyze this article in international trade law in general agreement on tariff and trades. Yes. So it's adopted in 1947. According to trade regime, that all countries, yes, trade between states, have trade interest how to make international trade between states, yeah, interstate cooperation. But in trade regime, it's also recognized that state may restrict, yeah, trade to protect human health. So we are trying to connect between pandemic issues and also and trade issues. How the trade issues and how investment issue in pandemic time. So we can refer to this article. So this article say that states may restrict trade to protect human health. So it's regulated under GATT article 20.b. So it's quite clear, all the audience, that even in normal time, all the states should trade each other by using a free trade principle, and already discussed before by Dr. Padilla, that about many principle in world trade and in trade system and trade law. But basically, the trade law should be based on the free trade. Yeah. So, but here in this context, so it's kind of exceptional clause here. State may restrict trade to protect human health. So the member state of WTO can restrict trade among states because why? Because the condition right now is still in pandemic time. Because the reason is how to protect human health. So it's quite funny if the government policy open the regulation, give the regulation how to increase, how to improve the investment rate, how to improve the trade between states by making policy of visa on arrival and also very easy license to come to Indonesia, for example. But here still in pandemic time, so it's quite funny the policy, I think, because according to this article, the highest priority is how to protect human health, rather than the trade issues. Okay, ladies and gentlemen, I think it's quite good points here in my presentation, how to connect between the pandemic time and also the rule and regulation in trade among states. Next, because time is very limited to me. Yeah. Okay. Do state response to the COVID-19 with the. So I think we talk about the story. Yes, the story of COVID-19. First in 21st December 2019, China reported a cluster of cases of pneumonia in Wuhan. Okay, and the next, the disease was eventually named in COVID-19. It's kind of novel coronavirus. But China failed to comply with its international health regulation. Yeah, to notify the WHO, yes, that within 24 hours of assessment of public health information. So it's clear. I think the article says that within 24 hours of assessment of public health information should be reported. Yeah. But on 20 January, so it's quite a long time, I think, more than 24 hours, the Director General of the WHO declared that COVID-19 was a public health emergency in international concern. At the same day, the Director of General issued a number of recommendations. So we can say that it's kind of breach the law, or breach of the provision of WHO provision, because at least 24 hours of assessment should be quickly reported. Yeah. Should be well informed to the public. But here it's quite a long time enough. Yes, it's nearly one month, I think. Okay, next. So yes, it's all about the dispute. Yes, the dispute connected with the pandemic. States' action and omission during this crisis will give rise to international dispute. Okay, and state-to-state dispute between state and international organization, also investor-state dispute, and also human rights dispute between state and individuals. So if Dr. Padilla already mentions about the investment dispute, but we talk about the possibility of dispute between state and state, or investor and also in state, investor and state, and also human rights dispute between state and individual related to pandemic time, related to COVID-19, because it's this regulated under international health regulation in WHO provision. Okay, but the international health regulation, however, were not designed to address the totality of the legal consequences of this crisis. So it's not clear this provision about the dispute among investor, among state, and among individual, and also dispute related to human rights. Okay, I think in this point that international regulation dispute settlement mechanisms exclude private entities and also individual and are highly dependent on the willingness of states to submit their dispute to compulsory adjudication. Next. But until now, I think this issue about the pandemic time, about the COVID-19, still in public debate about who will be responsible for this pandemic of COVID-19. Okay, according to International Health Regulation Article 43, any state party impacted by an additional measure may request to the state party implementing such a measure to consult with in order to find a mutually acceptable solution. So it's clear, okay, but the solution may request to the state party into such a measure to consult with in order to find mutually acceptable solution. Ladies and gentlemen, I think this article we can read in article IHR in the full text concept. But here I only mention all these two articles in article 43 and 56. Yeah. So this consultation do not prevent state party to seek to settle dispute regarding the interpretation of application of the IHR through the separate mechanism established in Article 6. So here, all the disputes should be brought to WHO Assembly, World Health Assembly. This is the decision-making body in WHO. Okay, this is just about the dispute channel, how to settle the dispute arising from a pandemic COVID-19. Okay, next, I think it's nearly over, I think, my presentation. Next, please, next. Okay. Okay. I think next, it's not, we skip it. Okay. Okay. So here the most dramatic action under international health regulation. Yeah. The Director General on the advice of the Emergency Committee. So the Director General of WHO should refer to Energy Committee, yes, Emergency Committee. Yeah, it's composed of individual experts. Yes, so it consists of such individual experts. Yes, public emergency of international concern, and also the consequential adoption of time-limited temporary recommendation of urgent measures to contain the outbreak of domestically and control international spread. Yeah, after some hesitation that the commentator criticized that excessively, yes, the differential towards China, and Director General declared that the coronavirus outbreak as a public health emergency of international concern on the and issued rather conservative temporary recommendation excluding the travel. Okay. Next.
Excuse me, Prof.
Yes, I think I know that it's
limitation of time.
My time is over. Okay, I think let me conclude in this short, very brief explanation that in pandemic time we need a strong cooperation, good relation with another state, with another institution to manage or to handle the pandemic and also infectious disease such as COVID-19, and also in pandemic time, the trade regime also admit that or recognize that state may strict trade or maybe other commercial activities, yeah, because of the reason of pandemic time. I think that's all my presentation. Hopefully it's clear enough. Even my presentation is in mixed presentation in Indonesia and in English. Thank you. I think my presentation is okay. Terima kasih. And also time will tell us how the pandemic would look like in the next time. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Thank you very much, Prof. Ademaman, for this speech. If I can highlight some point of your presentation, the first, the global health governance in handling global pandemic is a multi-track policy and state responsibility, where there is some issues regarding how the state handling these pandemic issues that can connect to the international regime and legal system. It is also related to the theme from the next speaker, Associate Professor Rohaida Nurdin, where the theme is the dynamic of the international human rights law and Malaysian legal system. Please, for Ibu Rohaida, the time is yours.
Okay. Thank you, our lovely moderator, Ms. Ulil. Bismillahirrahmanirrahim, honorable guests, esteemed speakers, ladies and gentlemen. Assalamualaikum and selamat sore. Can somebody put on the slide? Yeah, okay. The topic of my presentation today is the dynamic of international human rights law, the abbreviation. I'll be referring to this as abbreviation IHRL and Malaysian legal system. You know, the reason why I picked this topic because I thought that I am, you know, obliged to make sure that my topic is within the big theme of the program. I'm trying my best here, okay? What I meant by dynamic is the relationship between IHRL and the Malaysian legal system, yeah? Specifically on the manner the legislative and judiciary bodies responded towards IHRL standard. So in doing so, I will be referring to some of the relevant and latest Malaysian cases. So that will be the second slide. That is my objective of the presentation. So in the next slide, yeah, my main proposition in this presentation is that although it is possible for Malaysian Parliament, the legislative body, to enact IHRL as domestic law without being bound to do so, which is highly unlikely for Malaysia, the implementation of IHRL will very much depends on whether Malaysia has the legal obligation to do so. So it's all about whether Malaysia has a legal obligation to adopt international law standard or not. So the issue here is whether IHRL binds Malaysia by virtue of the law of treaties or customary international law. So the answer depends on whether such standard is part of the General Assembly resolution, treaty, or customary international law. So now let's deal with the IHRL standard that is part of the General Assembly resolution in slide number 4. So we all know that General Assembly is one of the 6 charter bodies mandated by the UN Charter. Slide number 4, please. To conduct study and make recommendation for progressive development of international law and its codification. And the recommendation of General Assembly is made, deliberated, and adopted as a resolution and declaration. So for purposes of this presentation, I will look at the dynamic between the UN DRIP, the United Nations Declaration on the Rights of Indigenous People of 2007, and the UDHR, Universal Declaration of Human Rights 1948, and the Malaysian legal system. So next slide, please. As for the UN DRIP, Malaysia voted in favor of the declaration in 2007 before the General Assembly. And according to Article 42, Malaysia shall promote respect for indigenous people, subject only to such limitation as determined by law in accordance with international human rights obligation. And this Article 42 has to be read together with Article 46 of the Declaration, which provides that any such limitation shall be non-discriminatory and strictly necessary solely for the purpose of securing due recognition and respect for the rights and freedom. This leads to the issue whether UNDRIP creates legal obligation on Malaysia. In principle, of course, UNDRIP is a General Assembly resolution, so categorized as soft law that embodies a principle or standard or declaration of policy on indigenous people, which are not strictly binding norm of law. This principle was loudly echoed, by state when the UNDRIP was deliberated before the Human Rights Council. As you can see in slide number 7, states like UK, Germany, and Ukraine agreed that the declaration is not legally binding and merely establishes political norm. So the same tone was heard at the General Assembly meeting when the UNDRIP was deliberated. States including Australia, Canada, New Zealand, and Guyana agreed that UNDRIP could be an aspirational instrument with political and moral, but not the legal force. So I do not refer to Malaysia in any of this discussion, because basically before the Human Rights Council and the General Assembly, when the UNDRIP was deliberated, unfortunately the Malaysian representative was not making any statement. So thus, slide number 8, in theory, Malaysia merely has a political and moral obligation to implement UNDRIP standard, while in practice, Malaysia voted in favor of UNDRIP in 2007. What happened after that? Upon the favorable vote by Malaysia for UNDRIP, no amendments ever made to the existing law by Parliament to incorporate the UNDRIP standard. So at the same time, what judiciary has done, the judiciary in disposing cases on issues related to the rights of indigenous people have not taken cognizance to the standard in the UNDRIP. Instead, court adopt liberal interpretation to the existing provision because they are human rights legislation, not because they are part of the standard incorporated in the UNDRIP. Moving on to the UDHR. UDHR is the second General Assembly resolution which I wish to examine for purposes of this presentation. The dynamic can be demonstrated through Malaysian court ruling in 3 cases. It is reflected in slide number 9. I have summarized it in this slide. The first case is Merdeka University in 1981. The second one is Muhammad Izam case in 2002. And the third one is Indira Gandhi 2013. Why this is important to this presentation? Because the objective of the presentation is to demonstrate, the response by the judiciary upon the standard that incorporated in a declaration which Malaysia voted in favor. As regard to the first case in 1981, the issue was whether a decision to decline establishment of Merdeka University was a violation of the right to education under Article 12 of the Federal Constitution and Article 26 of the UDHR. In this case, Judge Abdul Qadir ruled that the Malaysian court will only have power on matters justiciable, meaning matters with legal and equitable issues, and not moral, social, and political matters. And importantly, the Judge Abdul Qadir ruled as early as in 1981 that UDHR is a non-legally binding instrument in Malaysia. The same ruling was made by the court in 2002 in the case of Muhammad Izam. So the issue here is whether restriction for consultation with lawyer is a breach of Article 5.3 of the Malaysian Federal Constitution, and also relevant provision of UDHR and two other General Assembly of 1997 and 1988 on the promotion and protection of the rights of detainee and arrestee. Basically, the issue was also whether international standard has persuasive value and assistance. So in this case, Judge Norma Yaakob ruled that the three General Assembly resolution referred to court in this case are declaratory in nature with no force of law and non-binding. So I managed to look into the later case of Indira Gandhi in 2013. In this case, Judge Lee Swee Sing made slightly a positive ruling in this case, in which he said Malaysia is a member of international law community and cannot ignore its commitment, including the UDHR, as it is part of the corpus of Malaysian law. So basically, the judge in this case were inviting all parties to the trial to look at UDHR for consideration. But he never said that it will bind the court in that particular case. So after looking at the responses of the judicial body here, and notwithstanding of the response, most of it negative, towards the General Assembly resolution in the next slide, I personally view that Malaysia has an ultimate duty to act in good faith. By virtue of Judge Lau Tapach ruling, while Malaysia is not bound to accept the recommendation of the General Assembly, Malaysia is bound to consider the recommendation. Not bound to accept, bound to consider the recommendation in good faith. And what does it mean, consider in good faith? Is to disregard the recommendation only with an explanation of its rejection. All right? And persistent failure to comply with any General Assembly resolution would amount to an abuse of Malaysian right to disregard resolution in good faith. Because in Malaysia, the reason for this, for my proposition, is that according to Judge Lau Tapach, Malaysia is also under a duty to cooperate with the United Nations to fulfill the goal of the UN establishment. Thus, I view that Malaysian court should respond to IHRL standard in the General Assembly resolution in accordance with Judge Lau Tapach ruling. So moving on to the next slide on the issue of IHRL standard in treaties. Malaysian court response depends on the status of Malaysia as dualist or monostate. I view that Malaysia is a dualist state. Not only me, many scholars in Malaysia view that Malaysia is a dualist state by virtue of relevant constitutional provision. So basically, there are three relevant constitutional provision that will be looked at. The first one is that the Malaysian constitution does not provide that international law or treaty as part of Malaysian law. Why is it like that? This is because Article 160 of the Constitution defines law as written law, common law, and custom. So compare this provision or definition of law in Article 60 to Article 6 of the United States of America Constitution, which provides that the Constitution, written law, and treaties as supreme law of the nation. So similar provision could be found in other monostates like Germany and Philippines. So basically, looking at the definition of law itself will support the proposition that Malaysia is a dualist state. As secondly, Article 74 of the Constitution, to be read together with the 9th schedule, Federal List, Item 1, read together, vested the legislative body, Federal Parliament, with the power to make law and implement treaties. So power to implement treaties belong or vested to the a separate organ, which is the legislative body. So on the other hand, the treaty making power is vested to the executive branch, according to Article 39 and Article 80 of the Constitution. This is affirmed in the case of the Government of State of Kelantan in 1963, where the issue was on constitutionality of the Malaysian Agreement of 1963. This is an international treaty between UK, Federated Malay State, Sabah, Sarawak, and Singapore. And what happened in this case is that the Prime Minister then was Tengku Abdul Rahman, executed the Malaysian agreement on behalf of all federated Malay state. So it was the power of executive body to enter or to make a treaty. So this is the synergy in Malaysia, because it's very structured. It's already provided by the Constitution. So executive has power to make, to enter into treaty. Legislative have power to implement and to adopt international law vis-a-vis the treaty that has been entered or made by the executive. Because of this synergy and combined with the definition of law under Article 160, it support the proposition that Malaysia is actually a dualist state. And Malaysian position as a dualist state was actually confirmed in a number of cases, but among the recent one was in the case of Asia versus Rafida in 2014, which we will look at shortly. All right, so that's for the position. Now we move on to, we continue on the dynamic of the Malaysian legal system towards international human rights law treaties. Moving on to slide number 12, please. Malaysia is a state party to 3 international human rights treaties. There are 9 main international human rights treaties, and Malaysia is a state party to Convention on the Right of Children, Convention on the Elimination of Discrimination Against Women, and Convention on the Rights of People with Disability. And under the principle of Pacta Sasavenda, every treaty in force is binding upon the parties to it and must be performed by them in good faith. Thus, Malaysia cannot avoid its commitment under IHRL by simply pointing to different domestic tradition or contradictory national laws and policies in Malaysia. Because of its treaty obligation, there is a general duty on Malaysia to ensure its domestic law is in conformity with obligation under IHRL. Now, the question to be asked is how the Malaysian Parliament responded towards the relevant human rights treaty or the human rights standard. Has the legislative body fully adopted the IHRL standard as Malaysian law? The answer is in affirmative. I mean, arguably, IHRL standards stipulated in CRC, CEDAW, and CRPD have been adopted as a national law via the enabling legislation such as we have Child Act and Disability Act, or through various amendments to the relevant domestic legislation. So we have seen here example of how the legislative body reacted towards the treaty obligation through adoption of enabling legislation or various amendments to relevant domestic legislation to adopt international law standard. But now the question is, what is the dynamic of the Malaysian judicial body? We have seen the legislative body. Now we move on to the Malaysian judicial body. What is the response to it? For example, CEDAW, one of the human rights treaties that Malaysia is a state party. How can it be demonstrated through a court ruling? Yeah? And for purposes of this presentation, I have picked these three cases to demonstrate the responses or the dynamic here. First one is a batteries case in 2005. It was a decision by the Apex Court, Federal Court, and followed with the second case, decision of the Court of Appeal, Nur Fadila in 2012, and concluded with a case decided in 2014, A-Asia case. Yeah. So what happened in batteries case in 2005, Judge Abdul Malik ruled that to invoke Article 8, yeah, and maybe I should explain here. Article 8 is is a provision that guarantee equality and non-discriminatory treatment based on various factors. And what happened is that after Malaysia becomes state party to CEDAW, the Parliament has amended Article 8 to ensure it is compatible to the principle of gender equality, because before this Article 8 has not guaranteed equality based, non-discrimination based on gender. Yeah, and additionally, Judge Abdul Malik ruled that to invoke Article 8, dispute must be between the state and the individual, not between two individuals. This is commonly referred to as the vertical effect of the Constitution. So if we were to relate this to the presentation by Prof. Maman just now, if there's a human right dispute between the individual and the state, then the human rights guarantee under Part 2 of the Federal Constitution might be used. But if the dispute is between an individual with another individual, yeah, which is related to the COVID-19 pandemic, it will not be covered by provision in the Constitution, because the effect that the constitutional right has in our current federal constitution is only vertical effect and not horizontal effect, means between individual with another individual. So let me move on. In 2012, yeah, a very specific ruling here by High Court Judge Zaliha Yusof. He ruled on CEDAW as a convention which Malaysia has become a party and therefore has the force of law and binding on Malaysia. So the Court of Appeal has recognized High Court decision but refused to follow its ruling. So this is so unfortunate, yeah, because we are subject to the precedent and High Court make a positive decision, but it was recognized by the higher court, Court of Appeal, but the Court of Appeal has refused to follow the ruling. But in 2014, the court ruled that in the case of Air Asia, the court ruled further that CEDAW has no application in Malaysia unless it is made as a domestic law. So in Malaysia, because of the dually status, the standard in the treaty will not be transformed automatically as a domestic law. It has to be adopted as a domestic law to bind parties in Malaysia and also the court that will hear the dispute. So basically what the court ruled is that the concept of monis, which is doctrine of incorporation. So monis, doctrine of incorporation is an automatic incorporation of treaties law as a domestic law, does not apply to the Malaysian legal system. This is an interesting case to me to be highlighted here in this presentation, because the court has confirmed that the judicial body has no power to adopt international law as Malaysian law. Instead, it is the duty of the parliament to implement treaties at domestic spheres. So moving on to the third part, which is the last part, yeah. On the issue of, in the next slide number 14, on the issue of international human rights law standard that is part of customary international law. So in what manner Malaysian court responded to this standard? Yeah. So the Malaysian legal system doesn't provide for direct application of customary international law by Malaysian court. Instead, it has to be through English common law, which is part of Malaysian law, according to the constitution. And application of English common law in Malaysia is through Section 3 of the Civil Law Act 1956. This principle can be clearly examined in the ruling of the case of Majlis Perbandaran Ampang Jaya 2006. The federal court ruled that court shall is a mandatory on court to apply English common law as administered in England as at 17 April 1956, provided that it is permissible by local inhabitant and local circumstances. So basically what this slide is saying is that customary international law, yeah, although it's different than treaty law, it has a mandatory it imposed mandatory obligation on member state of General Assembly, even though if the particular member state has not signed or ratified the relevant treaty. But when it comes to Malaysia, it's not automatic. The application of customary international law as part of Malaysian law is not self-execution. So it has to come into Malaysia through English common law. So meaning that the customary international law has to be adopted by English court as their customary law, and then the Malaysian court can adopt such English common law into Malaysian court by virtue of Section 3 of the Civil Law Act. But there are certain requirements, yeah, specified by this Section 3. So there are certain date, there's a cutoff date of 17 April 1956, meaning that Malaysia can only accept English common law that's adopted or administered in England as at 17 April 1956. And the customary international law cannot be accepted if it is not permissible by local inhabitants and local circumstances. So the dynamic of Malaysian judicial towards customary international law can be demonstrated through the ruling in in 4 cases. Yeah, I've prepared a table in slide number 15. It's a short table. Yeah, there's a earliest case of 1987 in slide number 15, please. The judge was Shankar J. Okay, and then the same judge ruled a year later in a village holding case. Yeah, and there's another case, Commonwealth of Australia, in 1990, and MBF Capital case in 1997. But what I wish to highlight here briefly is that for the first case, for Narogni case, the relevant customary international law was on the right of innocent passage, while for the village holding case, it was absolute sovereignty, and for the Commonwealth case was on restrictive immunity. So coming back to the Narogni case, yeah, this right of innocent passage was adopted by English court in 1949 as a customary law. Yeah? And so the issue was whether the customary international law bind Malaysia automatically. And according to Judge Shankar, Malaysia adopt dualist approach for not only treaty, we have discussed just now, yeah, for treaties obligation. So Malaysia adopt dualist approach, but Shankar J was saying not only for treaties obligation, for customary international law, Malaysia also adopt dualist approach. And what does it mean? It means that it requires an enabling legislation before the customary international law could be adopted in Malaysia. So meaning that customary international law is not self-executed in Malaysia. So the same principle can be found or has been made by Shankar J the next year with regard to customary international law of absolute sovereignty, which adopted by Malaysian court through the medium of English law, and as well as the principle in the case of Commonwealth of Australia that involve customary international law on restrictive immunity. But interestingly, that I wish to highlight here, for the Commonwealth Australia case, the court, Gan Chin Tuan, do not limit the English common law as administered before 7 April 1959. Instead, he was saying that, you know, for customary international law that adopted after the cutoff date of 7 April 1959 may be applied by Malaysian court as Malaysian customary international law, but as a persuasive in nature. Because it's compared, when we look at section 3 just now, for the English common law that administered before 7 April 1959, the status is shall. So Malaysian court shall adopt. But for customary international law that administered post 7 April 1959, Malaysian court may still refer to it as a persuasive in nature. Okay, so the next slide, 16, in the case of Ketua Pengarah Penjara Kajang in 2017, this is a very interesting case, but there's no direct cognizant or application of customary international law in this case, but it has been referred to. Yeah, the issue in this case was whether an accused who was convicted for murder but declared as mentally sick while waiting for his death sentence execution. So the question is, should he entitled for stay of execution? Yeah, because of his insanity. So this is another case in which the Court of Appeal took cognizance to the position in the UK and other customary common law countries, including India, and also to the customary international law that prohibits the carrying out of death sentence on an insane person. So this is the reason why the Court of Appeal has sent back the matter to the High Court for retrial because the applicant application for stay of execution because of the new evidence of insanity was rejected or declined by the High Court. But the Court of Appeal in this case have an opposite decision and was of the view that the High Court, the trial court, should look into the customary international law and those principles in the common law countries. So basically, we cannot sentence an accused person who became insane after the conviction but prior to the execution. This is tantamount to a customary international law and also a part of the standard that incorporated in the Convention Against Torture and the ICCPR. Okay, so I think I have covered all three positions. So my concluding remark is protection of human rights in Malaysia requires state to take cognizance and implement international human rights law, and the traditional lawmaking process, i.e. through parliament, is the constitutional way to adopt IHRL standard in Malaysia. At the same time, judicial interpretation technique exists that allow for IHRL to be part of domestic law without going through the traditional way. So there are new judicial interpretation techniques such as 21st century constitutionalism and creeping monism that is being introduced and applied in some of the Western countries, including US and Canada, for such dynamism to be operated by the judiciary within a particular state. Yeah. However, this is not yet the dynamism adopted by the Malaysian court. With that, I thank you and thanks everybody for the attention. Thank you.
Thank you very much, Ibu Rohaida Nurdin. Very interesting topic to be talked. And if I can highlight some point from the presentation is that Malaysia adopt dualist approach, which is explained that Malaysia has implemented the IHRL as referred in some of judicial recognition, but however, still many issues to be addressed. The first is how the legislative body fully adopt the IHRL standards as a Malaysian law. And then why Malaysia does not have treaty obligation under the ICCPR, ICER, and ICER, and how the impact to the legal system in the dynamic of legal system in Malaysia. Other issues also can be discussed later in the Q&A session. Now we go to the next presenter. We have Professor Tri Lisiani Prihartina from UNSUD that will presenting with the title The Legality of Indonesian Marriage Abroad, International Private Law Perspective. For Prof. Trilisiani, please, the time is yours. Okay, question in the chat room. We will read the question in the Q&A session and then continued with the second term, the live question from the audience. So the audience can choose to raise hand and addressing the question. Okay. Okay, please, Prof. Tri.
Can you hear me, Mbak Ulil?
Yes, yes, we can hear you, Prof. Tri. Please, the time is yours.
I'm the last speaker. I am not good, long. Takes a long time. It's, basically, I want to present the legality of Indonesian marriage abroad from the international private law perspective. This come up to the I cannot the next is there. Oh, okay, yeah. If you look at the problem, actually, this about 2013, there is a regulation in Indonesia that changed the position of the people who want to marry with the different religious background. And from the research finding, actually quite a lot of different types of solution went. The people face the mixed interfaith marriage problem. There are 4 types of solution that we collect from the couple of research. The first one is one of the party changed religious voluntarily. So it means the consequence of this first solution is there is no more different religious background. And the second one is that the one party converts to the other's religions during the marriage. It's the second effort is different with the first one. When the first one is the people who convert or change religious for the last, but the second they only convert for its merit purpose. We acquired number of cases. For the example of the second types, who's that artist about this? In Indonesia, a couple of artists choose the second one, and then after they married, they come back to the previous religious. So it is quite interesting because from the legal point of view, it's acceptable, but from the value or moral point of view, especially from the a religious point of view, it's a reason actually to divorce when one of the converted people back to their previous religions. And the third one is each party keeps his or her religion with permission from the first court decree. So actually, this third types, it's occurred to the case of Lydia Kando and Jamal Mirdad. Even um, even some other artists and ordinary people also choose this model. And the fourth one is but unfortunately, in the case of Lydia Kando, at the end they are apart and divorced. It's not the issue, but the fourth one is marriage is carried out more than once according to the parties' religious and belief. It means that the couple, the husband and wife, they took uh, two, they took the marriage 2 times. It is a case in Surabaya when first they married according to the Christian, and then the second one, and they also took the Buddhism the systems, and they followed the Buddhism what's that process. It seems, but the third interesting one is, although they took two steps of marriage, 2 kinds of marriage, but the government it's only recognized once. So which one is it's depend on the parties, depend on those wife and husband. But if we refer to the theory of law, then the last one is recognized, but it's by human being. It's not by God. And actually, what I choose these topics is just to discuss the latest system of interfaith marriage. How is the latest system in Indonesia? Because it's quite interesting, because this is a problem for so many years. I start with the notion of legal base on Indonesian marriage law. It is the national marriage law in Indonesia, which is occur from Sabang until Merauke. And in Article 2.1, it mentioned that I just point the important keywords, that marriage is legal when it's occur based on their own religious and faith. So it's reflect that this national marriage law is a religious marriage. There is no marriage when there is no religious or faith marriage. It is quite different with the article at the Bergredwitz book, that the wet book from the Netherlands, that at the moment for marriage it is not acceptable anymore, but some others issue like non-married issue, it's still we still depend on this book. But historically, it is different, because if the national marriage law based on religious marriage, but this uh, historical regulation is only focused on private issue. It doesn't connect with the religious at all. Okay, this the point of the changing issue from the Netherlands to the Indonesian. Before there is no at all connection between legal marriage and the religious. But no, it still depends on the Article 2.1. And then in terms of married abroad, Article 56.1, it mentioned that this marriage, I mean the marriage abroad between two Indonesian, it's legal if it's occurred based on the regulation on this abroad regulation, but it should not across the regulation from in Indonesian National Merit 1974 that we call it Undang-Undang Perkawinan. So it should in line with whatever the reasons, whatever the article in Indonesian Merit law. It is the second point, the second ayah. It mentioned that the merit should be registered in official 1 year after arriving in Indonesia. So there is quite a lot of problem when Indonesia, between the Indonesian different religion, they want to marry here. So far, they could not. After the national marriage law in since 1974. But then they took effort to go abroad, married over there, then come back to Indonesia. Hopefully, the government acknowledged this marriage. And it's already mentioned here. After they come back 1 year later, it should register their marriage. So what happened if they are not registered? That it was case of Julia Perez case when she tried to go to the government official and ask them, say, I want to divorce because I'm not compatible anymore with Perez from France, and they are married in France. But the government official asked the Julia Perez and asked them, are you married? Yes, I'm married in France. Are you, were you registered you're married? And she's surprised because she thought that, oh, I thought every man knows that I already married with that guy, the Perez. But the government, Indonesian government official in Kantor Catatan Civil registered official, he just said that, oh no, you are still single because according to Indonesia, you are not married yet. Yeah, but if there is the consequence of unregistered marriage, and another further consequence is the status of children. But at this moment, I'm not talking about that, but because I want to focus on this registration. And yeah, there is international. Actually, according to Indonesian international private law, actually marriage is a national jurisdiction. There is another theory that marriage actually, that another private law, the issue of private law is not a national jurisdiction, but some of partial international jurisdiction. Like, for example, is arbitration. But according to marriage, it's entirely depend on the country, whether they want to arrange or whether to allow or do whatever. But Indonesian is bound by CEDAW. That, but the bonding to CEDAW is not totally, because there is some reservation about that. We already have Undang-Undang number 7 and 1984. Another one, in terms of international private law problem, especially in the marriage problem, we depend on Article AB. It's actually in the general regulation that is we inherited this from Netherlands. It's 16 about the lex patriarchy. Yeah, it means that in terms of marriage, it's about the status of two people. So it depends also what the law then will apply to them. So it's this principle says that it's depend on the people who have this problem, depend on their status. So if to Indonesian they are marriage abroad, then back to Indonesia, it's still Indonesian marriage law bound them. Okay, and then so another problem is it's Article 18AB. It says this. It's about the principle of like Lucy celebration. It means that so whoever marries abroad, it should follow the process, the regulation of marriage abroad. So this another issue when it's arise. So what happened if, like for example, and the marriage abroad it's against the Indonesian marriage law. So that's the interesting issue that actually we could discuss further. And the other is about the public order threats. It's what I mentioned just now, that would happen if the regulation abroad is not in line with Indonesian marriage law. For example, there is different religions. There is according to article that I mentioned earlier, Article 2, here, yeah, which one? Yeah, Article 2, Ayah 1, that marriage legal only if you fall, if it happens with the religious and trades procedure. That is according to religious marriage. So what happened if let's say the marriage in India, for example, because in India there is India hasn't recognized marriage, religious marriage. It's only a public private marriage. Then this one that we call it public order. Public order means that every country has their own jurisdiction to decide what kind of marriage they want. So whether the problem will rise when the marriage across the country. So about religious marriage, for example, we have a case about Yudhisthira's case when the Yudhisthira and the husband married in Singapore, if I'm not mistaken, in Singapore, and come back here and they have a children. So they say, okay, I already already registered, so it means our marriage is legal. Actually, we can make a lot of discussion about this, but actually what it was the sample of public order, yeah. But public order not only in terms of national level, but also in local and international level. For example, international level, for example, there is no a sex and gender is they still can marry, although you have no religion, although you have different gender, or some radical one is if they are same sex, you can still marry. But in a different country, regulate them with differently. So I remember with Bu Rohaida, yeah, it's actually it's between public order is the order on the regulation that force the country, local or international, to follow their own orders or own regulation. So it's differ between one and another countries. For example, in Indonesia, you cannot have same-sex marriage. But in America, you cannot have polygamy. But 7-Eleven, it's all right, but no polygamy. Yeah, that is the expression of how the regulation are different from one another country. And this is the one that I already mentioned, that actually I start from actually before and after Indonesian Independence Day. Before we are deal with Netherlands, that in a Haji there is no reason or no boundary if two uh, party with different religions want to marry. That is basically about that. But in Indonesia, start from the first one. This is Article Undang-Undang 22, and until the latest one is that I highlight. It's Undang-Undang 24 year to 2013. Actually, this is the one that allow, I will mention later, that this is the article that allow women and men with the different religions to marry. But the thing is that they have to ask the permission from the court. So it means this special article, it's aimed to the people with different religions or different faith. So start 2013. So it's depend entirely to the judge whether they have permission. They will give permission or not. But actually, this is what I said. It's the exit, the emergency exit, actually. And another difference at the same undang-undang, it's different article mentioned. It should report. It should report. So after you got the permission and you have a law to report it to the government official to register. So what then if you are not registered? Because registration is very important in the marriage. If you're not registered, then there is no legal consequence between husband and wife, although there is limited consequence with the children. Because if they are unregistered, then you have to give other proof that the children has a relation with the father or biological relation. Okay, and this is that actually I just want to say the challenge of mixed interfaith marriage, that the Indonesian regulation about the marriage, it was extended actually to the interreligious or interfaith marriage. And the other problem actually is, so to what extent, if it will go further, and it will, I believe it will, because we are living in the globalization where some other movement that's already when the other people want to have the right as well. So how is the government deal with? For example, for number 2, I will give example like same-sex marriage. They want to have the right as well. So it's depend on then the society and the the judge whether they want to allow this kind of marriage. And if for mixed religious marriage is done already, they have a right to ask permission. It's already regulated in the Undang-Undang Admin Duk. But about the same-sex marriage, we don't know. Because for me, law is actually is a man making a law, so it will change depend on the people themselves and the government themselves. Like the latest planning of undang-undang. It failed because there is some other society complaint about that. Okay, yeah, I think this all. Thank you, Mbak Olin.
Thank you very much, Prof. Trilisiani Prihatina. This is very interesting topic. That they cannot marry to the different region inside the country, but if they go abroad and come back to Indonesia, the government will accept the register of marriage 1 year after arriving in Indonesia. This is very interesting topic to be discussing, how the legal system toward those kind of issue. Okay, now we will go to the Q&A session. We already have many questions in the chat room. We have listed the question. Mr. Anang, maybe you can present the question. We have for the first question to Dr. First question for Dr. Nur Fadila Muhammad Ali.
Yeah, okay. Yeah, all right. So thank you very much. Yeah, I've seen this question just now. Why does Calvo doctrine is not favorable? Well, the Calvo doctrine is a doctrine which evolved in Latin America in 1930s to 1970s. So basically what it meant was to highlight the sovereignty of Latin American states and to call for equality of rights of foreign and domestic investors. So basically they are trying to make foreign investors in equal footing as of local investors, and to ask the foreign investors to acknowledge the sovereignty of Latin American states. Then that is why it is not favorable in the perspective of the foreign investors at that time. So what they wanted was the foreign investors at that time wanted minimum standard of international minimum standard of treatment, which is at that time relatively higher than what is accorded within domestic law. Okay, now going to the next question which I saw was about food protection and security. Am I right, Ulia?
Yeah.
Yeah, about food protection and security. What is the level of protection of food protection and security? Well, there is also discussions about how we can expand that protection, but basically predominantly the view is that it only covers physical protection. Like for example, in one case, AAPL against Sri Lanka, whether the government has put a certain active action against the attack by armies or use of force against which gave impact to foreign investment premises. So basically, the predominant view is to protect the investment properties from harmful effect or from physical violence or seizures. So that like cases which were brought of, for example, Saluka, Wina, etc. So those are the scope of food protection and security, more on physical aspects. So thank you very much. I think I have to leave the session because I have a meeting coming on. So I wish all the best for everyone to continue with the Q&A session. Thank you.
Okay, thank you. Thank you very much for the Ibu Fadila Ali with us. Now, move to the next question for Professor Ade Maman Suherman. The question is stating Okay, please, for Professor Ade Maman, the question.
First, I would like to say thanks first for the Dean of Faculty of Law, Husin, to Dr. Fadila Muhammad Ali. Thank you for your presentation and for your attendance in this conference, because we have another meeting after this session.
Yes.
Very much. Hopefully, we will have another cooperation with USIP in the near future. Thank you very much.
Yes, inshallah.
Okay.
So.
Yeah. Okay. Thank you. And then next question for Professor Ademaman Suherman. The question.
Yeah.
How, as stating in the presentation, about no. Okay. This question is from Ibu Nur Zuhaida Osman from USIM.
Yeah, thank you for Bu Nur Zuhaida for your questions. Yes, it's I think quite interesting topic. I think about pandemic and infectious disease and also how to anticipate globally through global governance of course. I think yes, about the COVID-19. This is global issue already, and in ASEAN, how the ASEAN countries to manage this pandemic conditions. I think ASEAN countries to make more effort, more collaboration in 10 countries and in 10 member countries. You know, ASEAN has 10 member countries, and also we need cooperate each other, like Indonesia and Malaysia, both bilaterally or in multilateral system. So I think in an ASEAN level, even I know that the pandemic condition is different from one country to another country in ASEAN countries. For example, in Brunei or in certain countries, still low level rate in pandemic conditions. So Indonesia now already number one, I think, in ASEAN countries. So we have to collaborate regionally in ASEAN countries, and we don't blame each other, of course, yes, between our ASEAN countries. And also we need to involve all the international organizations, yes, because we need to coordinate between one state and another state. Also, the involvement of international organization is needed as well. For example, from WHO and also for multinational corporation that involved in how to provide a vaccine for COVID-19. Yeah, because all countries know from, for example, Australia already worry about Indonesia because the death rates increase from time to time, and then Indonesia has very high density of population to 150 million people. Yes, so I think it's good. Good solution and good recommendation, I think, and I agree to this question and this comment. Yes, thank you. For the next question, I think from Aji Yunasis. Yeah. What are the limitation of global government intervention on national government? Of course.
On national government.
Yeah, as I already mentioned before, that the keyword here is we need to collaborate and involving all the elements in national or in global communities. Yeah, both state to state partnership, or also we involve also the international organization, non-governmental organization. So because government cannot work without other element or other institution. And also in global community today, one nation cannot stand alone without other help from other nation. Okay, so it's it doesn't mean that it cannot intervention from non-governmental organization. No, it's I think it's quite common that in global solution we need more involvement in more elements and more institutions. So it would be useful protection for our citizen, yeah, particularly for how to save our life. Okay. Emergency that has been increasing on this freedom from the international law, the protection how the state is because of legal obligation has been based on the time. Yes, blame China for failing to stop. Yes, it's important question, I think, and it's quite interesting to answer, I think, because it still have time. May I present some slides, Ulil, because it's very strong related with these questions.
Okay, yes, the technician will help to presenting the slide from Prof. Ade Maman.
Or
Mr. Umar, please. Yeah.
I will share from here, okay?
Oh, okay.
Wait 4 minutes, yeah. Okay, I will share from sini.
Share.
Ini ya.
Share screen.
This one?
Share screen, bro.
Yeah. I need to enter my documents. Which one? Mana?
Mr. Umar is helping.
Oh no. Ini
dari sini aja, Mbak.
Okay. Yeah. It's done. Okay. Okay. Can you see my presentation here?
Yes, we can. Yeah, we can see your presentation.
Yeah. I think I tried to connect the facts, yes, between the facts in China and the rules in international law. Okay, I think yeah. Okay, this is a kind of a legal barriers. Yes, we can. It's quite a kind of difficulties because. Yeah, they can of the failures of many countries to effectively contain and mitigate the damage from the spread of virus would only make it more difficult to prove causation. So it's the problem is about the causation. So if you want to sue China as a state who breached the international law, so the obligation that should be presented in the court, and also the difficulties is we should make it more. We can kind of difficulties, yes, to prove the causation, and also China would ever agree, yeah, to appear before any international tribunal or international court of justice to defend its action. Yeah, so we'll never agree. I mean, here, the United Nations must establish. So it's my opinion that to me that United Nations must establish an international commission of investigation comprised of the highest level of international health, medical, and international law experts to assess the extent of the damage to entire world and examine the China's action, including a quantitative amount of damage. So it's kind of one of our solution, I think. And then here, yes, I think the same content with the previous slide here. And then China thinks that it's breached the international provision, yeah, because it's breached the international covenant of economic and social and cultural rights. So a right to the highest attainable standard of physical and mental health. So it's the keyword here is the highest attainable standard of physical and mental health. So if we try to punish the China through a United Nations system, it will have kind of difficulties as well, because why? China will try to vote to use his right to for veto to memveto, yes, to vote that China doesn't agree with the decision, because China is one of the big five who has voting right, veto rights in United Nations. So that's the problem. So now the provision, I think China breached the law under the provision of International Covenant on Economic, Social, and Cultural Rights, because it's right to the highest attainable standard of physical and mental health. So it's kind of the international regulation or international law that already adopted by all nations, I think, including Indonesia and also I think Malaysia. I think that's my answer about, yeah, I think one principle in international law, state cannot be punished under other international other international law, because it's based on the principle of equal right and sovereignty, the principle of sovereignty of every state. Yes, yeah. So it's also here that the settlement dispute, the system in international health regulation, also it doesn't regulates about how to punish a certain country that already breached the international health regulation. I think that's my questions. That's about the expression from China, from the United States of America, that in the civil lawsuit filed on Tuesday against the Chinese government or Chinese Communist Party and other Chinese official and institution. Here in Missouri, one of the state, the impact of the virus is very real. Thousands have been infected and many have died. Families have been separated from dying loved ones. Small businesses are shuttering their doors, shuttering the doors, and those living paycheck to paycheck are struggling to put food on their table. This one statement. But China's government lied to the world about the danger and contagious nature of COVID-19, silence whistleblowers, and did little to stop the spread of the disease. This is the statement from Mr. Smith that must be held accountable for their action. This is just about statement, not about the punishment from the international court. Okay, right? That's my explanation related to your answer, to your questions. Next, it is still some question for me.
Mr. Anang, maybe you can present the next question.
How many questions?
Still have.
Because maybe it's too difficult or too interesting. I think this topic, yeah. So many participants want to ask about this topic. Which one? It's too small to read here, but can you show me in a bigger size?
From Mr. Edi Setiabudi, question for Prof. Ade Maman tentang pendapat kebijakan pemerintah dalam penanggulangan pandemi COVID dalam bentuk bantuan sosial tunai yang justru menimbulkan banyak konflik secara horizontal. Bagaimana pendapatnya, Prof?
Oh, yes, ini menarik ya. Jadi ini about social security ya, bantuan sosial. Karena ini pandemik, Indonesia pandemik COVID-19, banyak orang unemployment, jobless, semua perusahaan juga close, tutup. Ini juga banyak economic difficulties, social problem, juga kemungkinan the possibility of criminal rate juga akan meningkat. Ya. Jadi ini one of the government policy how to help the people in the grassroots level by giving them kind of bantuan tunai, social assistance, social aid for the people who lost their job in pandemic time. Yes, I think it's the idea is very good. I think it's good to be implemented, but how to operate, how to manage, and how to distribute is the problem of how to distribute in a good manner and also in good way, in good manner as well. So I think the idea, I agree to the government to give them kind of this kind of assistance or also social security, and also I know the problem from this project. I think about data. Yes, the data between the local government and the central government doesn't match each other, so it's opposing each other. From the local government, still I want to use to apply the most current data, but from the central government, still using the old, very old data. So it's the problem comes from there. Yeah, but the idea, I think it's good one. I think it should be appreciated by. Uh, it's just honestly, I agree with the idea. Yeah, because a lot of people get hard in life or the difficulties in how to be survived in social life. Okay, I think that's my idea and my also my opinion. Apa perbedaan prinsip undang? Oh, it's another one. I think it's about merit.
For Prof. Trilisyani. Thank you very much, Prof. Ade Maman Suherman, for the answering question. For the next question will be addressed to Prof. Trilisyani for one of the audience about the differences between principal marriage law in Indonesia.
Okay, I try to answer sebetulnya perbedaan prinsip apa antara Indonesia dengan Malaysia. Mungkin nanti yang Malaysia bisa dibantu Bu Eda ya, Rohaida. Tapi sepanjang yang saya tahu, kalau di Malaysia itu betul-betul tertutup kemungkinan perkawinan antara perbedaan agama dan kepercayaan. Jadi mereka sudah tidak membuka sama sekali. Ya, ini dan kondisi sekarang ini berbeda dengan di Indonesia. Basically, Indonesia juga sama karena pasal 2 tentang sahnya, pasal 2 ayat 1 tentang sahnya perkawinan itu juga jika dilakukan menurut hukum agama dan kepercayaan. Nah, ini tetapi dengan undang-undang Adminduk itu membuka kemungkinan bahwa perkawinan itu bisa terjadi kalau ada izin dari pengadilan. Jadi izin untuk mendaftarkan perkawinan yang sudah dilakukan menurut agama ke Adminduk gitu. Jadi ke dulunya catatan sipil lah ya, sekarang Adminduk. Jadi kalau di Indonesia sekarang lebih longgar. Cuman satu hal ya, tidak hanya perkawinan sebetulnya, apapun yang kita lakukan itu kan harus based on religious, humanity. Nah itu harus seperti itu, karena kalau tidak apa, undang-undang itu akan bergerak, akan dinamis. Apa ada yang menjamin bahwa kita ke depan itu tidak mengakui same-sex marriage? Karena kalau di Indonesia kan undang-undang itu dibentuk asal Anda kuasai anggota dewan selesai. Dan rupanya kita ada sejarah yang kurang bagus, ada background yang kurang bagus, di mana banyak ternyata anggota dewan itu yang terlibat oleh korupsi ataupun ada permainan di dalamnya, dimanapun ada itu. Tapi kalau itu menyangkut untuk hal-hal yang sangat penting yang menyangkut kehidupan publik, maka kita mau turuti apa seperti itu. Jadi at the end itu adalah kita sendiri yang harus menentukan mau seperti apa. Ya, saya rasa seperti itu. Jadi itu prinsipnya memang berbeda. Tadi juga kalau menurut international customary law itu kan relatif sebetulnya. Ya, jadi tidak apakah semuanya yang dari international law itu harus kita adopt. ternyata kan tidak, karena ada juga reservasi, ada teori-teori lain yang membolehkan kita untuk menolak dari apa yang tidak dinilai tidak sesuai dengan lokal setempat. Dan ini juga diatur sebetulnya dalam international instrument international yaitu dalam konvensi Wina. Itu kan diatur juga bahwa pelaksanaan hak asasi manusia, kalau dalam case kita kan adalah dalam case merit, itu pelaksanaannya disesuaikan dengan nilai lokal setempat. Itu jangan lupa. Ya, jadi seperti itu. Saya rasa jawaban dari saya, Bu Ulil. Untuk Mbak siapa ya? Ada lagi konsekuensi hukum tadi ya, saya baca kalau nggak salah. Apa ya konsekuensi hukum dari perkawinan di luar negeri? Jadi begini, kalau perkawinan di luar negeri itu sesuai dengan apa yang diatur dalam agama kita, karena pasal 2 ayat 1 kan menyatakan perkawinan sah jika dilakukan menurut hukum agama dan kepercayaan. Sekarang dilihat pada masing-masing agama mengatur perkawinan seperti apa gitu. Nah, kalau perkawinan misalnya saya menikah di Malaysia dengan sesama muslim, balik ke sini ya nggak apa-apa. Tapi kalau ternyata kasusnya Junisara balik ke sini, nah there is question. Karena begitu kondisi sekarang akan mendaftarkan pada adminduk, ya, maka akan dilihat kalau itu yang non Muslim. Tapi kalau yang Muslim maka dia mendaftarkannya di pengadilan agama. Akan dilihat apakah betul syarat dan rukun perkawinan di luar negeri itu dilakukan sesuai dengan hukum agama. Jadi kalau kita Muslim kawin di luar negeri pengen punya kenang-kenangan a place of merit, nah, di mana ya, di London misalnya, tapi ternyata di sana dilakukan misalnya dengan sesuai dengan rukun dan syarat perkawinan secara Islam, nggak masalah. Nanti akan menjadi masalah seperti kasusnya misalnya beda agama pergi keluar pulang ke sini. Pertanyaannya adalah apakah pendaftaran itu adalah bukti sudah terjadi perkawinan yang sah? Sah menurut hukum setempat. Ya, mungkin dia dapat surat dari luar negeri, yang itu pasti itu salah satu syaratnya. Atau dia menurut hukum setempat yang dikeluarkan oleh misalnya kedutaan atau apa, itu mereka sah menurut hukum sana. Tapi begitu balik ke sini belum tentu loh. Karena yang kita dapatkan dari pendaftaran itu adalah bukan, kan beda antara buku nikah, kemudian bukti pendaftaran. Tetapi bukti pendaftaran itu atau pelaporan adalah bukti awal untuk memberikan legalitas pada anak yang lahir. Ini penting karena anak kan tidak ngerti apa-apa, sing dikarep kan orang tuanya. Ya, jadi itu penting untuk anak. Tapi untuk perkawinan kedua orang itu nanti dulu, ya kita lihat dulu menurut apa dilakukannya. Saya rasa itu. Jadi satu hal lagi bahwa bukti pendaftaran itu hanya bukti dari negara bahwa sudah terjadi perkawinan di sana. Sah tidaknya dikembalikan lagi. Tapi itu bukti awal untuk urusan administrasi lah seperti itu. Karena kan semangat dari kependudukan itu kan dia nggak ingin saya, pokoknya saya ditunjukkan buktinya saya sudah itu. Kalau ada penyelundupan di dalamnya dia nggak ngurus itu, adminduk itu nggak ngurus sampai ke sana. Oke, saya kembalikan pada Mbak Ulil. Mudah-mudahan itu menjawab ya. Kalau misalnya tidak, silakan Japri. Oke.
Thank you very much, Prof. Trill Yusiani. Very clear answer. And now we go to Associate Professor Rohaida Nurdin for answering the question. The first is the question related with Prof. Tri about how the implementation of marriage law in Malaysia for the person that want to marriage in the different religion. And there will be also another question. Yes, please, Rohaida.
Okey, terima kasih Miss Ulil. Saya minta izin untuk menjawab dalam bahasa Malaysia atau bahasa Melayu kerana soalannya dikemukakan dalam bahasa Melayu. Kedudukan berkaitan dengan perkahwinan di Malaysia, sebab Malaysia adalah sebuah negara federalism di mana 16 negeri yang berada di Malaysia diberi bidang kuasa negeri, ya, manakala kerajaan persekutuan juga mempunyai bidang kuasanya yang tersendiri. Jadi untuk hal ehwal yang berkaitan dengan masyarakat Muslim, tak kira dari segi perkahwinannya, sebelum perkahwinan, selepas perkahwinan, dan beberapa kesalahan jenayah menurut undang-undang syariah adalah di bawah pengurusan negeri. Contohnya di Melaka. Jadi jika melibatkan orang Melaka atau perkahwinan tu dilakukan di Melaka di kalangan orang Muslim atau salah satu pihaknya adalah Muslim, maka undang-undang yang terpakai adalah Undang-Undang Keluarga Islam di Melaka. Dan setiap 16 negeri ini mempunyai undang-undang perkahwinan atau kekeluargaan Islam yang tersendiri. Ya, tetapi walaupun mereka berbeza dari segi strukturnya, namun dari segi kandungannya adalah sama kerana setiap undang-undang Islam ini, keluarga Islam ini adalah berpandukan kepada sumber yang sama iaitu Quran dan Sunnah. Ya, itu pertama. Yang kedua, untuk yang non-Muslim, ya, perkahwinan mereka diuruskan oleh undang-undang persekutuan. Ya, jadi perkahwinan mereka diuruskan secara civil law, ya, civil law marriage. So berbalik kepada soalan tadi, jika seorang Muslim ingin berkahwin dengan bukan Muslim, ya, jadi kena kembali kepada undang-undang perkahwinan yang telah ada di setiap negeri. Dan secara generalnya perkahwinan antara seorang Muslim dengan bukan Muslim tidak dibenarkan, dan jika perkahwinan itu berlaku maka perkahwinan itu tidak sah. Ya, kalaupun ianya berlaku di Malaysia, dan ia tidak mungkin berlaku kerana perkahwinan itu harus dilakukan oleh, akadnya harus dilakukan oleh imam yang bertauliah oleh pejabat agama Islam yang tertakluk kepada peraturan, dan tak mungkin ada seorang pasangan Islam dan bukan Islam boleh dinikahkan oleh seorang imam atau kadi yang ditauliahkan oleh kerajaan negeri. Jadi apa yang berlaku, kebanyakan kes adalah mungkin mereka akan keluar negara untuk bernikah. Ya, jadi pernikahan di luar negara ini bukan hanya berlaku untuk yang melibatkan perkahwinan antara Muslim dan bukan Muslim, tetapi juga akan melibatkan perkahwinan di antara pasangan yang bersamaan jantina, ataupun juga keadaan yang melibatkan perkahwinan secara poligami, ya, dan mungkin perkahwinan yang memang straightforward, yang clean maksud saya, ya, di mana si calon isteri, calon suami belajar di luar negara, kedua-duanya berada di London dan kedua-dua Muslim berkahwin di sana mengikut undang-undang syariah, dan tak ada masalah untuk mereka kembali ke Malaysia untuk mendaftarkan perkahwinan tersebut. Jadi untuk tujuan pendaftaran perkahwinan, ya, sama ada perkahwinan itu boleh didaftarkan ataupun tidak, maka mahkamah akan permohonan untuk mendaftarkan perkahwinan di luar negara ini hendaklah dibuat melalui permohonan ke mahkamah. Dan mahkamah akan melihat kembali kepada syarat-syarat kepada perkahwinan tersebut. Ya, so kalau yang kes pertama tadi melibatkan kedua-duanya adalah bujang, ya, dua-dua mempunyai wali dan dua-dua adalah Islam, dan urusan pendaftaran akan menjadi formality semata-mata, tiada masalah untuk didaftarkan. Ya, proses pendaftaran ini adalah suatu proses yang penting yang macam Ibu Teri mention tadi, ya, sebutkan lagi tadi, ya, kerana pendaftaran itu akan melegitimiskan perkahwinan, sesuatu perkahwinan yang dilakukan di luar negeri. Dan untuk legitimiskan perkahwinan tersebut, maka syarat-syarat yang telah ditetapkan oleh setiap negeri untuk perkahwinan tersebut hendaklah dipatuhi. Alright, jadi untuk kes pertama tak ada masalah. So bila pelajar dah habis belajar, ya, kembali ke Malaysia, buat permohonan di mahkamah dan boleh terus didaftarkan. Dan menjadi pasangan suami isteri yang berdaftar, tiada lagi isu faraid, tiada lagi isu anak sah taraf atau tidak sah taraf, tiada lagi isu harta sepencarian dan hadanah dan sebagainya. Jadi tetapi ada 3 situasi perkahwinan yang disebut-sebut tadi, ya, yang sebenarnya tidak memungkinkan pendaftaran. Jika perkahwinan ini dilakukan di luar negara, kerana ia tidak mungkin dilakukan di dalam negara. Macam yang saya kata, perkahwinan itu hanya yang secara sahnya dilakukan oleh imam yang bertauliah, yang mana tidak mungkin akan melakukan perkahwinan yang tidak menepati syarat yang ditetapkan oleh Undang-Undang Perkahwinan atau Undang-Undang Keluarga Islam. Yang pertama, ya, perkahwinan melibatkan same sex marriage. Mungkin mereka ke luar negara dan mereka pergi ke negara yang mengiktiraf perkahwinan same sex. Ya, mereka dapat sertifikat, it was done under the Civil Law Marriage Act, ya, dan they become a partner to the marriage, and then bila dia balik ke Malaysia, dia buat permohonan, tidak mungkin akan diluluskan, ya, kerana untuk mendaftarkan perkahwinan tersebut, dia akan kembali walaupun ada gambarnya yang menunjukkan ada majlisnya dan sebagainya, ya, tetapi ia akan kembali kepada syarat asas perkahwinan, ya, kena ada lelaki dan wanita. So kalau lelaki dan wanita tidak mungkin akan diluluskan oleh mahkamah untuk pendaftaran, ya. Jadi they can only enjoy whatever protection that is under the state or the country in which they got married. Sama juga dengan perkahwinan lain agama. Ya, kalau yang si Muslim nak kahwin dengan Kristian, kat Malaysia tak boleh kahwin, so lari ke Sweden dan sebagainya, berjaya berkahwin dan ingin kembali ke Malaysia dan ingin mendaftar perkahwinan tersebut di bawah undang-undang syariah sebab salah seorangnya adalah Muslim, tidak mungkin akan diluluskan. Kerana syarat kepada perkahwinan tersebut bukan hanya seorang lelaki dan wanita, tetapi kedua-duanya hendaklah sekufu, ya, dan antaranya sekufu adalah sama agamanya iaitu Islam. Jadi itu juga tidak memungkinkan perkahwinan tersebut didaftarkan, ya. Tetapi ada satu kes yang agak kerap dilakukan di kalangan pasangan di Malaysia atau di Indonesia, iaitu perkahwinan yang dilakukan di luar negara, sama ada melibatkan pasangan Indonesia dan Indonesia, ataupun biar saya berbicara tentang Malaysia dan Malaysia yang mana dilakukan secara berpoligami, kerana dalam peraturan perkahwinan, ya, di Malaysia ataupun di negeri-negeri yang 16 tadi memperuntukkan jika si suami, bukan isteri tak boleh berpoligami, si suami jika ingin berpoligami hendaklah mendapatkan kebenaran daripada isteri. Ini dalam 10 kes memang 9.5 kes tidak mungkin berlaku. Jadi apa yang dilakukan oleh pasangan-pasangan ini yang mungkin melibatkan rakyat Malaysia sendiri, si lelakinya Malaysia yang sudah berkahwin, mungkin dah ada isteri 1, isteri 2, isteri 3, nak masuk isteri 4 dengan seorang wanita yang bujang. Jadi apa yang banyak berlaku sekarang di Malaysia adalah mereka ke Batam di Indonesia ataupun mereka ke sempadan, mereka ke Thailand, ke Yala, Naratiwat ya, untuk berkahwin di sana. Dan semasa perkahwinan dilakukan oleh imam di sana ya, imam di sana masih melihat kepada syarat-syarat perkahwinan kerana mereka adalah Islam, dua-duanya Islam. Jadi mereka pergi ke pejabat agama dan imam berkenaan akan pastinya melihat kepada syarat lelaki dan perempuan agama Islam ya, dan ada persetujuan ya. Dan kadang-kadang kalau yang isterinya itu adalah bujang, maka kadang-kadang ayahnya pun ikut ke sana untuk menjadi wali ya kepada perkahwinan tersebut. Perkahwinan ini mungkin ya atau kebanyakan kes boleh didaftarkan di Malaysia kerana undang-undang di Malaysia di negeri-negeri membenarkan pendaftaran yang sedemikian kerana dari segi syarat perkahwinan tersebut adalah menepati. Manakala nanti akan ada orang yang bertanya, macam mana pula ada peraturan bahawa mesti dapat kelulusan atau kebenaran daripada isteri pertama, isteri kedua, isteri ketiga. Yang itu telah pun diperuntukkan oleh undang-undang yang sama bahawa kegagalan mendapatkan konsen tersebut tidak menjadikan perkahwinan itu tidak sah. Ya, tetapi apabila suami kembali ke Malaysia untuk mendaftarkan, maka the suami will be subjected to another provision which will require them to a penalty. So mudah kan untuk suami. Jadi dia boleh kembali ke Malaysia, dia boleh bayar penalty. Kalau yang kaya-kaya datuk-datuk ni, just bayar penalty, daftar dan seterusnya berkahwin secara sah. Dan dengan cara tersebut, perkahwinan tersebut akan didaftarkan, dilegitimiskan dan anak-anak menjadi anak sah taraf dan juga urusan-urusan harta, hadanah, faraid dan sebagainya akan teratur.
Baik. Terima kasih Bu Rohaida.
Ya, sama-sama.
Very clear answer. Okay, because the limitation of time, we still have the second termin for the question from the participant live by raise hand. Is there any more question? Only one question from the participant by raising hand. Ask to the speakers. Is there any? No? Who want to ask the question directly to the speaker? No? There is no. Okay, because there is no question from the participant anymore, so we session. But beforehand, to conclude this webinar, please to all the speakers to give closing statements for maximum 3 to 5 minutes. We start from Professor Ademaman Suherman. Please to give the closing statement.
Ya, thank you, Mbak Ulil. Ya, ini menarik discussion hari ini. Yes, quite very interesting lecture. We already conducted a testing lecture between Indonesia and Malaysia, and organized by Faculty of Law, Jenderal Sudirman University, and also our partner from University of Kebangsaan Malaysia. Thank you for being with us here, Dr. Haida, and also Prof. Luciani, dan juga Dr. Fadila yang tadi sudah meninggalkan meeting. Baik, dalam kesempatan ini, let me summarize my presentation in bilingual presentation. First of all, I would like to deliver my conclusion in English that global governance in international law is really needed by international community, yeah, because we need good coordination, good cooperation among states and also between international organization and also non-governmental organization, and multinational corporations should be involved in managing the situation in pandemic time in terms of how to save the human life in the future. And also we need kind of horizontal and vertical perspective to minimize and how to restrict the spread of pandemic COVID-19. Yes, by involving all the organization and state as well, and also from all over the world. And until now, there is no certain mechanism to sue or to punish a certain country who really must be responsible for this case in terms of pandemic time in COVID-19. Even we know that the COVID-19 it's already happened in the first time in Wuhan in China, but until now the international community still try to see which provision that can be used, can be applied for this case. But I think according to international health regulation 2005, there is no certain regulation that can be applied for a certain country that involved in causing infectious disease such as COVID-19. So the international organization, in this case is WHO, has no authority, has no legal right or legal competency to sue a certain country that must be responsible for the international wrongful act. Okay, and until now, I think the difficulties is how to present the causation between the relation between the causality principle, yes, and the effect of pandemic time. So it's quite difficult to prove in the court, yes. And also the WHO has no strong unit to enforce its recommendation to its member states. Yeah, I think that's my conclusion, and also I hope this discussion can answer all the question. But I still open my space, or I have time to respond all the question outside this virtual meeting. Terima kasih. Jadi saya bisa nanti discuss after this virtual meeting, nanti bisa kita bincang-bincang kembali. Terima kasih dan mudah-mudahan bermanfaat untuk kita semuanya. Sepertinya sudah 5 menit ya, Ulil.
Lebih sepertinya, Prof. Terima kasih.
Bapak ini makan siang di tempatnya masing-masing. Terima kasih.
Terima kasih. Thank you very much, Prof. Ade Maman Suherman, for the closing statement. Now for Ibu Rohaida, please to give us the closing statement of your speech. The time is yours.
Okay, thank you, Ulil. I think I have included my closing remark in my presentation. Given a chance, I would like to emphasize that the presentation was about the Malaysian legal system, especially the two bodies, legislative body and as well as the judiciary, and how they interact with or how they responded to the international human rights law standard. I found that there's a lot that could be done by the parliament and especially the judicial body, yeah. And I feel like there's certain technique that could be adopted by the Malaysian judiciary, like the one that is currently adopted by many Western states. among others, 21st century's interpretation of the constitutionalism, and as well on the creeping monism, which I have not discussed in this presentation because it's yet to be a dynamician, the dynamic within the institution of the judiciary in Malaysia. So I am basically hoping for more proactive response on the part of the parliament, because parliament always prioritize their amendment, their legislation, and apparently human rights legislation do not receive priority, yeah, because parliament only sit 3 times in a year. So that's caused a backlog of passing of the enabling legislation. It's very fundamental for this two body to act or respond immediately, because I believe that in addition to the domestic law, the federal constitution, the protection of human rights in Malaysia is best if the court and the parliament take the cognizance on the international human rights law standard. Thank you.
Hi, Danuddin, for the closing remarks. And the next is closing statement from Prof.
Thank you, Olil. One thing that I want to summarize about my presentation is that actually this recent since 2013, then actually the marriage, mixed marriage in Indonesia is still same, but there is an emergency exit. But then again, it's come back to the value of all Indonesians themselves, whether it's society or whether it's parliaments, whether they will their own faith or their own value about the marriage, or they just will follow. So whatever the movement that at the moment run very fast in the society, then keeping the value is actually it's more important rather than just follow it. And our duties is how to convince, how to argue that the form of marriage is acceptable or compatible with our own value. I think that's all, Mbak Uri.
Thank you very much for Prof. Trilisiani Prihatina for the closing statement. Hereby this webinar has near come to end. Thank you very much for all the brilliant speaker for the important material to deepen our knowledge about the issues in dynamic law in Indonesia, Malaysia, and international world. Ladies and gentlemen, this webinar is near to end, but beforehand we will have photo session. All the participants please kindly turn on the camera, and in the count of 3 we will take your photo, so kindly give us your best expression. Okay, I will start to count. 1, 2, 3. Okay, once more. 1. Okay, thank you very much. All the invited speaker, all the participants, ladies and gentlemen, hereby we conclude our webinar has come to an end. Thank you very much for all the respected speaker, for all the constructive sharing of knowledge and active participants who joining this event from all around the Indonesia and the world. May this webinar will give all of us value insight upon issues related to the dynamic of law in Indonesia, Malaysia, and also in the international world. I would like to remind you at this point about the certificate of the webinar will be sent to your registered email maximum in 3 days after the webinar. On the behalf of the committee, I would like to apologize for the shortcoming in organizing this event. Thank you for your attention. Have an amazing day. See you on the next webinar series on Faculty of Law Jenderal Sudirman University. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Terima kasih Ibu.
Terima kasih Guru Haida.
Terima kasih Bu Ida. Ya, Pak Maman. Taryuni,
Prof Tri, terima kasih.
semuanya.
Alhamdulillah lancar ya. Terima kasih ya Ibu Woro. Terima kasih. Masih setia sampai.
Terima kasih semuanya.
Terima kasih.
Terima kasih.